village.
There are two, my lord. As per the above instructions, I along with my staff went to the land on 9/11/2022 to give protection to the petitioner, so and so, but one person by name, so and so, attended the place and raised issue, and I said land belongs to him and also caused a nuisance. Then I have secured the presence of two mediators, so and so. In the presence of them, conducted Panchanama. Therefore, I request the Honorable Court, please issue orders to Revenue Department, show the disputed land in survey number 540 of 246 at the outskirts of so and so, which is registered for.
Mr. We will issue notice, you pay the fine amount. We'll suspend the
May I submit, my
7
lords?
days RI.
With your lordship's kind permission. My lords, as far as the orders are.
This is, no, this is 2000 is subject to result of the appeal. We are issuing notice on your appeal.
Yes, my lord, the other say papers have been served.
The first respondent.
Yes.
Filed the contempt.
Yes. What do you say?
Lord, the decree passed, my lord.
See, that we can tell you, we have gone through the facts, we know the facts.
Yes.
We can, for your satisfaction, we can tell you the facts also. But the thing is,
Yes.
we were not initially inclined, but we came across his communication. Page 45.
I have seen.
So, you have seen, right?
Yes. This was filed before the Leonard single judge.
I mean, though he has acted beyond the scope of the authority, he should not have, because the boundaries of the land were defined in the order itself,
Yes.
and therefore he should not have. But the fact remains that he has made a request, somebody else came. But see, there has to be a willful disobedience.
Yes.
That element, prima facie, or at least, I mean, it's not a case where we should dismiss it in motion hearing, that it's open for him to say that though he has failed in compliance of the duty, but there was no element of willful disobedience.
Let's
But
apart.
my-
That's perhaps he can argue, so we will hear it.
Yes.
So we are asking him to pay 2000 rupees fine, and this 7 days RI will be suspended.
My lords, for your lordships, my lords, if your lordship kindly permit me, the law with regard to entertaining of a contempt application by the High Court directly
Yeah.
is per se irregular. High Court, my lord, the learned trial judge did not find at all that there is, my lord, the law is settled by the Honorable Supreme Court.
So you ought to have made a reference to the court under Contempt of
my lord.
Courts Act and this thing.
Either
That
advocate.
procedure applies in Andhra. If this
My lord, there is a
Telangana.
rule, there is a rule, section 15(2), there is also a rule, my lords.
Oh,
That is in apparent conflict with the
My
rule.
lord, for that, my lord, the office raised objection, how the contempt is maintainable and on.
no, because see, in Karnataka, there is a
Why is
practice,
there-
just a bit, Karnataka, there is a practice for everything. Like the High Court initiates the proceeding, like that, we don't know that this procedure not there, but contempt of courts, the district courts have no power to punish the contempt for itself.
Correct, my lord.
So if any judge finds that it has been violated, he has to refer the matter to the High Court, and thereupon the High Court does it.
Lord, even High Court can directly take, Lord, there is judgment of this honorable court.
So,
My
Mr.
lord, this is the rule and the law that by this.
Mr. AG, I mean, don't get into that. You must be remembering, Supreme Court has dealt with elaborately in case of, you remember, in the state of Gujarat,
My
a
lord.
chief judicial magistrate was arrested by police authorities. And they have said that under inherent powers also, this court being court of record,
My lords, the court can certainly, High
Court
Court
being
can take.
court of record can deal with, I mean, it's not dependent on Contempt of Courts Act only.
My lords,
So what if this court has invoked powers under 215, also Article 215?
correct, my lords. But
The powers to punish exist on this court in addition to
certainly, my
Contempt of
lords,
Courts
I
Act
fully agree, my lords. But
1970.
in this, my lords,
And we, so therefore we are entertaining your appeal, right?
placed.
See, give it the citation.
Yes, my lords.
You are appearing as a senior counsel, right?
Yes.
Mr. B.S. Prasad, learned senior counsel for the appellant.
Your Lordship, this matter pertain to service, subject to service, Your Lordship, wrongly posted before this honorable.
Wrongly,
Which
let the writ petition be listed before.
writ up.
Writ up. Service? You are this thing person placed under suspension on the
Yes, Your Lord.
grave misconduct, right? Let,
Your Lordship, the connect,
Let the-
if I two writ appeals, Your Lordship, one writ
Let
appeal
the-
is listed before the
yes, yes,
service
correct,
bench.
correct.
Post along with that man.
No problem. We have read it, so we are telling you this is the case.
Connected
Let-
number is,
Fine.
I am giving
Let-
connected writ appeal
We
number.
don't know. Let this writ appeal be listed before appropriate bench as per roster. Yes.
I mean,
Yes.
look, the present intra-court appeal is against a
Huh?
final order of the learned single judge.
Ah.
Look, the sixth respondent's ex-wife, now that they are divorced, had some medical problem when the writ appellant was a resident medical officer. He gave the first aid and then directed her to take some other
Sixth respondent's ex-wife.
ex-wife.
Oh.
They are now divorced.
Ah.
So she came to the writ appellant when he was a resident medical officer, complaining something. But he immediately gave the first aid and referred to saying that you'll have to take a scan and all that, which is not relevant over here. That Milord, thereafter, he invokes the jurisdiction of the AP Medical Council when the state was composite, alleging that I have conducted professional misconduct. The authority goes into the subject matter, dismisses his complaint. Thereafter, he goes before the Honorable Lokayukta dismisses it. Then after the state got bifurcated, he goes before the Telangana State Council. Telangana State Council also dismisses it. Then he goes before the Ethical and Medical Regulation Board, Registration Board. But I did not appear there. They suspended my practice for 6 months. Then questioning that, I filed a writ petition before this honorable court. This honorable court directed, rather relegated me to file an appeal under subclause 4 of section 30. However, stayed the order till 28/7 of 2023. I filed the appeal.
Where is that order writ petition? Page?
Yes. 2020. It is the one, not impugned one, the earlier one. Correct. One second, Mata. Earlier one. Page 100.
Page 100.
Now kindly see 103. 103, Milord, paragraph 5. Having considered the submission thus made, the writ petition is disposed of with the following direction. Your Lordship may kindly see the direction. The learned judge directed me to file an appeal and granted stay of the order till 28/7. If your Lordship now glances at page number 21, I have filed the appeal with a stay petition. Before the authority under subclause 4 of section 30, that is the National Medical Commission. Lord, though people do not pass any order in the stay application, I approach this honorable court that pending appeal at least stay be granted. Now the learned judge passes this order, the premise that I directed you to file an appeal, you did not file an appeal. Fact remains is I did file an appeal.
You represent a National Medical
Yes,
Council, madam.
Yes.
You should
My lord,
decide his application for stay. What happens if he succeeds in the appeal and by the time his license is suspended?
my lord, will.
Then what, like you decide
I
till
will
then,
state the step.
you decide the application for stay, till then the order will remain state.
My lords, I'm only stating this, my lords. I may be permitted to state two facts, my lords. The learned single judge passed the order on 3rd July 2023, my lords, page 100.
So for a period from today onwards, still consideration of stay, right?
No, my lords.
So
I
you
may be
want to say that he has suffered part of it, good,
No, my lords, that is not what I.
part of suspension.
That is not what
Good.
I'm saying, my lords. On 3rd July 2023, at page 100, my lords, the learned single judge asked the
He
petitioner.
didn't file the appeal within limitation, time limit.
He waited till the last minute. He slept over it
When-
for 20 days.
Ah,
The order was suspended till 28 July, my lords.
so when did he
2020.
file the appeal?
He filed it on 21st July, my lords. He waits for 2 weeks till the suspension is in force, and then in the last minute he files
Nothing prevents you from deciding his application within 1 week or by tomorrow also, or
Manoj,
I don't know whether you would do so on 15th August, but
Manoj, instead, and
these matters are not to be contested matter.
stay application, my lord.
That's what you should say, that we will decide. Nothing, no argument.
We'll take instructions on the timeline, one day, my lord, within how?
Then what do you want? He will be happiest man. We will admit it, grant stay. So this thing,
Only on the timeline. Whatever your lordship feels.
we are directing.
Whatever your lordship.
Your submission, we understand, madam, that people will be after you for saying that why did you give a concession? So we will say that you say that it will be decided within such time limit as may be fixed by this court.
Right.
This statement we will record on your behalf, and we will fix a timeline.
Very well.
Right?
Very well.
We know that your difficulties as counsel, both of us have been there, right?
I'm deeply obliged, madam.
Yes. All right, mark the presence. This intra-court appeal has been needless to that the
GP for revenue.
uh, uh, yes. Okay, ma'am. 'Not to entertain this entertain. You appear for
Respond number 1, my lords, the petitioner before the learned single judge.
one.
Yes,
2 to 6 I.
So, Mr. What is this interim order? Not to entertain,
yes,
no,
may,
no, not to entertain his document and to entertain only, that will be decided at the time of decision of the writ petition. Whose application?
my lords, may I say one thing, my lords? Various documents were
No, that's correct.
I'll submit one. Various documents which are filed before the learned and single judge, which led to passing of this order, my lords, are not filed in the writ appeal. May I submit that, my lords? Your lordship may have it on Monday, because that documents will show what is the fraud played upon on the.
No, Mr. This is the most unfortunate thing which you have widened the scope of this proceeding under Article 226 to such a extent that the parties will play fraud on each other. And no, forget about this case. We are taking this opportunity to express something. For fraud played, and this court in exercise of powers under Article 226 will determine who has played fraud. So all civil courts, according to us, in entire state should be abolished, and we should have as many as maybe I don't know how many judicial officers as judges of this court. All judges of this court should try this thing, civil suit for declaration of title, deciding F-line applications, survey, boundary marks, dispute pertaining to identity. All this is being done under Article 226. And top of it, we are not dealing with the writ petition, but this is an interim order.
Yes, my lords. One thing, my lords.
All right, fine.
My lords, the sub-registrar is also the mutating authority, my lords, now. That's the reason these
Mutation doesn't confer any right. You should understand. We will cite at least, we will keep on this thing now 10 Supreme Court judgments to tell you that mutation in his favor, your favor, and Mr. GP Revenue's favor also in personal name will not confer title on him.
Yes.
You are Mr. Praveen Kumar, right? Shrikant. So supposing if we direct that Mr. Shrikant's name, you are fighting. So therefore, as by way of an interim measure, Mr. Shrikant names be mutated in the revenue record. We ask him to file F-line application and it is allowed. That doesn't confer any right on you to establish fraud in an appropriate proceeding. Interim order is not fraud.
My lords, may I say one thing, my lords?
This is
I
very
place on
peculiar.
record those
This
documents.
is very peculiar order, not to entertain.
On Monday, I'll place on record the documents.
No, not Monday. We are admitting it. We have many other things to do.
My lords, I'll place on, your lordship may take it up at 2:30, my lords. I'll proceed and record the documents.
What was your prayer in the writ petition?
My lord.
No, 1 minute, Mister. We are just trying to understand some queries. So we want to, in the first place, ascertain district collector has the authority in law to determine title. No, forget about this case. We are putting a query to you as an officer of the court. District collector in state of Telangana has authority to examine the title. No. Then how is this interim direction? Just a minute. How is this interim direction that he will not entertain in relation to subject property document, and he shall consider your this thing F-line application only, online application, whatever.
Malats, that-
How can
The direction is.
this is no.
Whatever sites Tahsildar and joint register. If the Tahsildar and joint register, if the district authority as well as the rotating authority. What happened in this case? I had put the documents and Patadar passbook from 1960. Without issuing any notice, my passbooks were cancelled and
When was Pattedar passbook issued to you, Mr.? Date.
part of the petition record.
So 1960 it was issued to you. 90.
Yes, much add.
So then this passbook was cancelled when
In 2021.
21 without notice.
The notice. And Malats, they say,
Then what did you do? You filed a writ petition.
well, that is how, yes. The passbooks were cancelled. Malats. They say, I executed a sale deed in favor of respondent number 6. That sale deed, admittedly, I have not executed. I have filed an RT application before the sub-registrar and the joint tahsildar asking for that document because they say I have executed the document. In reply, they say, no such document exists. That is not placed in the return. That's the.
No. So then what? So we have only understood that your passbook was cancelled in 2021 till without notice to you. Then what did you do? File a writ petition here.
Yes.
Huh?
Yes.
You filed a writ petition. What this writ petition, right?
Yes.
What was the prayer? You filed a writ petition after 2 years. This 21, it was cancelled. You filed the petition in 23, right? 8950 of 23 after 2 years.
Not to know subsequent.
Ah. All right. So as soon as you came to know, you filed a writ petition in 23. What is the prayer in the petition?
Challenging the action of page 22 is the main prayer.
Action mandamus declaring.
Respondent one.
One thing, Mr. You are a young man. We are trying to tell you this. There is a urgent need to this thing. Amend the way you claim the prayers in the petition, right? There is no mandamus can be issued for declaring the action of respondents. This is what you have learnt in what has been taught to you in LLB course, constitution subject. What has been that a mandamus can be issued to declare something?
May I read the whole prayer?
No. Can it be issued? Can't be. So this is wrong, right? Yeah, we will read, but we thought that you are amenable to reason by your appearance. So that's why we are taking this opportunity to tell. It's not that you alone are doing. Everybody sitting here is doing it. Mandamus by declaring inaction or action. You don't this thing. Then you don't raise any objection that this is prayer is not properly worded. That is the purpose of advance notice to you. You never say that it should be prayer should be Mr. Petitioner prays for following reliefs, column paragraphs 1, 2, 3, so that judges have difficulty in reading. Yesterday, a senior counsel argued a matter on a relief which was not claimed in the petition. Yesterday's instance. So you are a young man, lot of petitions, many more petitions you will file. So we are just putting you to notice that it's better if you do like this, right?
And last one, the index filed before the learn English.
No, declaring action of not registering the document.
And today is the name of responsibility in revenue record with respect to land activity.
Registering against the order.
So delays. As absolutely illegal and
Registering. You don't do sub-register office anymore. Basically, he has registered a document which was not to be. Then what's the remedy under cancellation of CAD? Then we want to take. All the time, depending reputation. Cancellation is not. Yes, the thing is send it to say it's quite a lot. We have not been. Mister, it's an this thing. It has the order has not been passed after hearing you. So then you have a remedy to file an application seeking vacation of stay. So have you filed an application seeking modification? When? 8/6/23. It's pending. We will request learned single judge to decide your application within a week after hearing opportunity. Correct? Yes. Fine. You should have said it should be disposed of. Otherwise, we thought we were putting this young man to trouble. He came under tension. Like don't be stressed when a query is put. You should maintain your smile and remember this, that the prayer clause has to be separately. This thing put distinct 1, 2, 3 columns so that it is easy for judges to read. One paragraph, one half page of prayer, difficult to comprehend. And if we have any difficulty in comprehending what you have pleaded, whose laws it is, not ours. Therefore, we are telling everyone, this intra-court appeal, will request the learned single judge. Fine. We are requesting now.
Non-agriculture. Again, we cannot look back into agriculture.
We don't know. This is an interim order. You are all these matters you should bring to the notice of learned single judge where the rate petition is pending. We are requesting. We are ourselves. Division bench of this court is requesting the single judge to decide within 1 week. We will grant you the liberty to bring to the notice of learned single judge all subsequent events. We cannot control in a intra-court appeal the action of respondent number 5, Tehsildar, a petty officer who is, and anything done is subject to this thing results as a final result of in this writ petition and appeal, and we have all the powers on earth to undo what he has done. If he starts we don't nothing will happen.
You can cancel it like.
He will not run away from the country with passbooks, and along with the land he will not run away from the country. Your land will not disappear. It's already there. This intra-court appeal. This is an interlocutory order, Mr. Ex parte. You have the remedy of appeal, and therefore we don't want to entertain it. We are granting you liberty. This intra-court appeal has delay condoned, madam, condonation for delay condoned, 5,
Yes.
same,
Item 6 is Surendra Reddy, Chief for Medical and Health, A. Prabhakar.
yes.
Maybe those.
This we have entertained, right? Order.
Notice.
Notice, we have entertained this.
Similar challenge, 110. No, not LCC. This is 85%.
85% local.
Mr. Ravi,
Regard to management quota, my lord.
this is something different, not so the batch where that 85% local.
With regard to corporate quota, my lord. This is with regard to management. The management quota also they are saying for 85% of.
Out on the question of admission. Petitioner in this writ petition has challenged
We
This one got
granted
also as
some-
possible.
That's why I'm saying we granted some,
Or-
same principle will apply.
admit 4 weeks time to file counter, and after this he prays for time to ascertain. He is unable to state, and then he prays time to ascertain whether in a similarly situated, in a similar matter, any interim order has been granted by this court. By a division bench of this court, right?
Item 7, Surendra Reddy, Medical and Health, A. Prabhakar.
It is. Lord,
Ah,
it's a covered matter, my lord.
Covered man.
With regard to admission in the BDS, my lord.
no, not covered. We have admitted it.
So this is the case where, my lord, the petitioner got admission in the last academic year, my lord.
This,
But it-
this also we have admitted. He is unable to state, you
209.
find out.
990
Page number 77, the covered
So
order.
say so, that it is similar petition has been entertained.
20990 of 2023, my lord.
20
990
of
23, my lord. This second.
23. Yes,
Yes,
see, madam, 20990 of 23, what order has been passed?
21025 also, my lord. Order copy I have filed at page number
Two-
21025. Order copy I have filed at page number 77, my lord.
77. So Mr. Rao, same,
Batch of cases, my lord, you are lost.
We cannot pass a different order.
Batch of cases, my lord.
Learned
five cases,
counsel.
you are lost as passwords.
In this writ petition, comma, page 78 facts are similar.
Only the thing is that here the petitioner is declared ineligible for BDS. There
Where
it is
is-
not ineligible for MBBS.
Where is the change? That's what we are, so that she can type and save time, right?
You know, so same order, my lord. Only the change is that here she was declared ineligible for MBBS, and this petitioner is declared ineligible for BDS.
BDS. Instead of MBBS, BDS, it will only BDS.
See, madam, this same order. Same order here, MBBS stroke BDS, you write BDS, right? Huh? Full stop. Therefore, interim order. So university is directed to permit, indicate web is, you are her or his,
Her
her web option for admission to BDS course, right? Permit her to participate in the ongoing counseling
And BDS.
for admission to BDS course, right? List for analogous hearing along with WP number so and so, right?
order copy by today, my lord.
Not today, of course.
Keep you.
Lordship, I'm appearing the petitioner's lordship.
Yeah.
Lordship, the petitioner's property was mutated in favor of a third party lordship. The petitioner had challenged the mutation proceeding before the Honorable Lokayukta Lord, who is the second respondent. The Honorable Lokayukta had passed an order, Lordship, directing the third respondent, who is the district collector.
Which provision? Lokayukta has power under Lokayukta Act to direct deletion or mutation of
Understood.
anybody's name.
I'm not challenging that,
No,
Lord.
no, you are saying you are seeking enforcement of the order passed by Lokayukta in this writ petition. We are not the executing authority of orders of Lokayukta.
Lokayukta had directed the collector, Lord, to pass.
You understand the query or you don't understand? Which, first of all, if you are seeking enforcement of an order passed by Lokayukta in this writ petition, you have to tell us that Lokayukta has power to issue such a direction under Lokayukta. Secondly, he has no power to execute his own order. Then You don't have any other remedy except to file a petition under Article 226. 3 questions, please answer.
Lordship, my only grievance is, Lordship, Lokayukta had
Our grievances answer, our grievances answer 3 questions posed to you. Which provision of Lokayukta Act? Which Lokayukta Act?
Section 7,
Section 7, he has
clause
power.
4 mil.
Huh?
To investigate the matter and to direction will be.
Where is the act? You are for Lokayukta.
Yes, ma'am.
So if he issues a direction to someone, forget about this case, not complied with, Lokayukta is what?
Hello.
Toothless tiger. What? So what?
Let powers are conferred under section 7,
7 for it to enforce.
not enforcement.
How?
To investigate the matter.
No, that's correct, Mr. We are,
Inquiry.
since young man is unable to tell us, we revert back to you. Section, we have understood that section 7, he has power to just investigate. But supposing if his direction to mutate the name of some person is not carried out, where does he go? No provision under Lokayukta to enforce
Yes, my
the
lord.
order.
Only the Lokayukta is having power to investigate the matter and give direction to the competent authority.
Mr. Collector, who is the appears?
Yes, my lord. I am appearing for the respondent number 1, 3 and.
So somebody,
Here is-
you a citizen, not the matter, not to argue. Some citizen petitioner has made some complaint against mutation to your collector. Should he not look into it, or everybody should be driven to Lokayukta, then High Court, then only you will wake up and you should volunteer that we will decide his complaint
In fact, my lord,
after hearing affected opportunities, given all affected people an opportunity of being heard. Right?
true, my lord.
If a citizen comes to you with a grievance, you being an authority, should you not
Mandate.
look into it?
They
Then,
should.
then there's nothing to contest, nothing to argue in this case.
This case, what has happened, my lord, after the order passed by the Lokayukta,
You have decided the complaint.
sorry, your lord.
You have decided the complaint.
Yes, my lord, notices were given. They did not attend to come to the
I have
office
attended, Lordship.
from 34 page of first.
That dispute we will not decide here, that whether you appeared or not appeared.
Proceedings were initiated, Lordship, till Feb.
No,
2020.
Mr. Don't appear in the proceeding before Lokayukta and then file a petition and then dispute. We can't decide disputed questions of fact. We don't have any this thing. We don't have any CCTV footage of proceedings of the office of collector where we can find out. And we don't have this thing. We don't know how petitioner looks like. So we don't know whether he appeared or not. We will say that she's saying that you didn't appear. You are saying you appeared. Disputed question of fact and be decided under Article 226.
They have themselves attached the notices, my lord, from page 34 onwards.
Madam, so if he undertakes to appear before you, then will you decide?
No, your lordships, because
No.
the order is specifically saying within 3 months from the date of receipt of, that is the specific direction given. And in the year 2018 onwards, notices were given, he did not attend. After 5 years is coming.
No, so you will not decide, right?
My lord, a order,
We asked you if he appears, will you decide? You are saying no.
no, if your lord,
We are not enemies, madam. That it's not that whatever we say is against you always, all the time. Please listen.
true, my lord.
We asked you that if he appears, will you not decide?
Now
You
we
said
decide.
no.
I'm sorry, my
You
lord.
will decide.
In view of the order of the Lokayukta,
Nobody is trying to find fault with you, madam. We are
Very well.
only saying that please decide his complaint.
very well, your lord.
Nothing to argue in this. You argue in matters where nothing to argue, and you will conclude in the matters where we expect you to contribute in 5 minutes. This is what is happening. Is it a matter to be opposed by mighty state?
It's not a
Is it-
matter to be opposed as far as hearing is concerned, my lord. As far as the documentations which have been filed, I'm just bringing it to your lordship's notice, my lord, that after 5 years, he comes up to this court.
No.
saying that
So if he
is
comes,
not
no.
compliant.
Supposing if he comes after 5 years, so you will never decide.
That is not.
This is
not true,
what
my
we
lord.
stand.
Uh,
We will reject it by saying that even if he has come after 5 years, his grievance is still pending. Therefore, a continuous cause of action, and the principles of, you want this thing, remarks from this court against your administration?
No, your lordship.
What is there to contest, madam?
It is not. Right,
You are not-
can be given, my lord.
No, the land, whatever his grievance doesn't belong personally to the collector, neither to you nor to the collector, right? Supposing his land he's claiming, we don't know. It doesn't belong to you either or to the collector personally. Why should you oppose? You say that we will look into his complaint
Very
by
well.
giving notice to everybody. It is remained pending for his inaction.
True.
You say that you please, court should take an undertaking from him that he appears on a date before us.
Very well.
Mr. Don't come. We will
I
appear.
undertake to appear, Lordship.
We will not issue any direction.
Lordship,
She says that when you appear before it, collector will decide from the date of appearance within, madam,
Yes, my lord.
how many days?
3 months, my lord.
3 months.
I undertake to appear.
Don't appear. It's your choice. We are not fixing any date.
Lordship.
We don't want you to file a contempt petition against collector. Right? That also we can see. That you are a litigant and who doesn't want redressal of his dispute, roaming around here and there. Court bird. Right?
I have appeared, Lordship.
Court bird, right? Huh? So you make around this thing before the office of the collector, don't appear, then come to this court. What is this? Go to Lokayukt. So he has no jurisdiction.
Already in the year 2018 itself, we have disposed this matter, my lord.
So yes, madam, have you taken a decision?
Have you taken any decision because you have given notices in 2019, assuming he has not appeared?
Yes, ma'am.
You could not keep quiet, no? Your notice itself indicates
Yes.
that you will take further action
Yes, ma'am.
based on the record. Have you taken any action? If not taken, then.
And if you have not taken any action, you will take action within, it's his choice, appear, not appear. You take an action.
Very well.
After putting the part.
You say that we had given notice.
We have.
You should have passed an order by now, if not already passed. You may not be knowing whether
I-
order. Yes. So it may be that you have passed an order. We will grant you the liberty in case no order has been passed
Very
at page 35, you will do so within a month. In this petition, the grievance of the petitioner is that the now, Mr. Don't file a contempt petition. Appear. Huh?
Appear.
Appear before collector.
I'm for the petitioner and representing it on behalf of Zulfikar Alam.
NCC. Madam NCC. We have
NCC.
dealt with similar matters.
Yes, similar.
Order
matter.
you have?
Yes,
Yes.
I have the order.
He has the order. So and so. You should keep ready, madam.
Format order, just keep ready.
Keep ready.
Subject, subject to 85%.
Heard on the question of admission. Learned counsel for the petitioner in this petition has
Well, I may be prompted.
LR substitution of whom? Appellant, petitioner or respondent? That 8, sub 1. No, 8. So you say, taking into account the order which this court proposes to pass, it is not necessary to issue notice to respondents, right? Then say collector shall decide, shall hear all necessary parties, including LRs of respondent number 8,
71 page relevant.
petitioner as well as LRs of R8, right?
Order on the.
Yes.
Well, I may be permitted to appear in this matter. Well, this matter is squarely covered by an order given by your lordships at page 92 to 94. Well, your lordships have placed relevance on the term
But this requires admission.
92 to 94. My lords have laid
He
relevance.
is saying no, so he needs to be heard, right? We asked him, he said no. He
Respondents-
indicated to us in sign language that no, not covered. At least he wants to contest. We will have to, after hearing both of you, we need to find out.
Well, but the relevant
Yes.
92 to 94.
Interim order,
Yes, ma'am. I'm
not covered. We thought final order. Interim order.
Yes, only and then. In terms of 92,
Similar circumstances we have entertained. Yes. So,
lordships have placed relevance on the rules, my lords, which give importance to the term residence as being one where the
what is your
majority
pass plus 10 from
plus
Hyderabad?
10 from Telangana. I've done my entire schooling in Telangana.
Then plus 2 you went out.
Only 2 years my father was posted as a lecturer in Tamil Nadu, my lords. Therefore, plus 2 only I did in Tamil Nadu. Otherwise,
That case also Tamil Nadu. That is also similar.
Tamil Nadu.
IPS officers
Yes,
in
yes.
Tamil Nadu and lecturer.
is a prime. Maybe so, my lords, but the principal lordships have laid down.
It this way, in earlier days, At least when I was in school, college, I can tell you one thing. Boys, girls from Hyderabad used to go to Guntur. Ravi tutorial was one where for coaching, and there used to be one institute in Nellore where joining that assured the seat into medicine for whatever reason.
Yes.
So for only 2 years, I was abroad.
Ah, that you will argue.
Well, that may be argued at the final. But my lords have given relevance to the rule,
Learned senior
not to the
counsel.
regulation.
Learned senior counsel for the petitioner submits that the writ petition involving similar issue has already four six one or what is that?
Your lordships
It's
have referred
definitely 95 supplement.
95 supplement. I'm not aware, but my lords have referred to a WP
Ah,
3160 of 18.
in view of aforesaid submission and with and with
Anytime.
yes.
After the first phase counseling, the result may come anytime today or tomorrow. So he may be directed to come.
Yes. You take the copy.
Yeah.
95 supplement. 95 supplement volume 1 you get madam SSC.
Lordships, there.
Volume 2, 3 and 4.
The Supreme Court
supplement
judge.
volumes. Right.
There's a Supreme Court judge.
Siliguri, yes, I
Siliguri
think so. Siliguri municipality. Anybody there? Rahul and other
I'll
people.
find out and supply to them.
Rahul and other people not there.
Rahul 95.
Rahul.
Supplement.
Next.
Deeply obliged.
Max,
Ah,
your lordship, sir.
Yes, Mr.
To the sample.
Prabhakar. we are reminded of flood victims when you appear. So you have made such an impact on us.
So the respondents are not being provided the facilities to the children who are studying in the hostels and residential institution. In
So what
terms
is
of
the material not being that it is not facilities not being provided? Any representation you
Yes.
have made?
Yes, I have
Coming-
made the representation on 18 to 2023 at page 184 million. And I have
123,
applied- 184 million.
184.
Yes, at page 184 million.
Ah.
And the substantial material papers have been enclosed before your lordships at page 41, how they are being.
Mr. Prabhakar, heard on the question of admission. Issue notice.
Lordships, A number 1, I prayed before this honorable court to direct the respondent to submit the status report at present. Your lordship may please it to her.
No. Let them seek instructions, then we will, let them say. We obviously in the, this thing, their counter, they will disclose what facilities are being provided.
Worst situation in the across the state, Milord.
That's why,
Sufficient.
that's why we have immediately felt this thing convinced
I'm
and
deeply
has,
obliged.
without hearing you,
Yes, sir. I'm deeply obliged.
a genuine cause.
Yes, obliged, deeply obliged.
Yes. Encroachment at full tank level.
Constructions of
Huh?
full tank level,
Ah,
where the irrigation departments write a letter to the officers to take action. but-
representation made? No.
Yes, 32 to 35, your lordship.
Date.
Your lordship, 3/7/2023, one thing I want. They considered my application and written a letter to the officers to take action, but no action is.
Heard on the question of admission notice. See, Mr. 95, how are you? I didn't see you today morning. All right. So this thing interim orders parity is required to be maintained. Like 95 supplement volume 1 SCC or 4 SCC some page. So like in a similar case, we pass one order. In view of principles of parity, that order has to, similar order should be passed in that other case also. We cannot take a different view that in your case we grant stay, her case we deny stay. The principle of parity, interim orders only. Consistency and parity requires that even interim order. It's, I remember 95 supplement 1 or 4 SCC some page. My lord says Siliguri municipality, that has to be Siliguri municipality. Must be see and bring a printout. Yes.
To maintain consistency.
Consistency, yeah. Consistency, probably, yes.
One day, my lord, your lordships have directed me to file the judgment copies of the earlier writ petitions. I have filed it along with the memo, my lord.
So your this thing, constructions haven't been demolished and you are claiming compensation in a writ petition under Article 226. Learned single judge has held that the relief claimed in the petition is barred on the principles of res judicata and has granted you the liberty to agitate your grievances, lay a claim in a properly instituted civil suit. Because you will understand, Mr. One thing. We, of course, we are duty bound to hear you and we will hear you. But one thing you will understand that there are how many these petitioners, 2 are there. What was the market value of their shop or house? How much was it? Whether the house or shop is constructed on the land belonging to them, number 1. Number 2, whether construction raised on that land which belongs to them was raised in accordance with law and there is no deviation. It is not in contravention of any master plan. And then third, what was the value of these houses, right? All these are, this involves adjudication of facts, which in a writ petition to what an extent we can do. And there are case laws to the effect saying that for violation of a fundamental right, the court can grant compensation, but that will be token. It can be 5 lakhs, it can be 1 lakh, it can be 50,000, it can be 50 lakhs, whatever. Right? So all this is, I mean, I don't know, you may be much more, you may be entitled to much more in law, like your shop may be 1 lakh crore, we don't know, or 1,000 crores. We can't determine that in a writ petition. They will obviously not admit if you say that my shop is worth 1 crore and goods were also there which were taken away by their employees, like mobile phones, all of them these people took away. This we can't adjudicate. This was difficulty, so that later on when we dictate, you shouldn't say, we will hear. That's, so all these questions, it is our duty to put you to the notice of what is transpiring. Otherwise, you will say that I was not aware and court has dismissed my petition appeal on this ground, which I did not get an opportunity to address. So we have told you. Now proceed. So first submission is no res judicata. Now what was the petition earlier filed? Yes, the learned single judge is quoted.
Yes, ma'am.
When did you construct the house? Where did you construct the house or shop? We don't know. What did you construct? When? Where is the building permission? Building permission. Your house, your plot, your plot. Which plot? Petitioner number. No. 1 minute. So petitioner number 1's land, what is the particulars of land? Petitioner number 1. Purchase the land. Purchase plot of land. How much? Measuring. This all, that's why we emphasize on the need for synopsis. Need for synopsis. All this you could have given. Now you will turn pages and we will write it down. So plot of land measuring how much? Where? Yes, sir. It's same 65.
Who is the petitioner in 17095?
Very same petitioners, my lord, very same petitioners.
So very same. What happened to this order passed in WP 17095 of 2019?
No, now we have got it. What happened? It has attained finality.
Yes, ma'am.
This very petition says, para 6, order has been set aside in writ appeal.
No. That's what I'm saying. So far as 17095 is concerned, that has attained finality. So the direction there was to go before the competent civil court. Now, in addition to the land, let us say there it was 40 feet. Now another 10 feet is added. So 40 itself is need to be established. So another 10, can a writ petition be maintained, Sridhar?
So this petition pertains to 10 extra feet. 40 feet you have accepted the order. You have go to civil court. And now this, how much? 10 feet you are here. No, if notice is not given, but notice is not given, the action is bad. But what consequential relief to which you are entitled to, that does not necessarily follow from mere declaration that action is illegal. We can declare the action to be illegal and say that they have not followed the procedure prescribed under, supposing for your satisfaction under Corporation Act or whatever act. But still, the question of grant of compensation in a writ petition cannot be decided. That's what we, in the beginning, we told you, Mr. And the strong reason why we should not follow the order passed in WP 17095/2019, the petition filed by you only. How can you expect us to pass a different order this time? Because the combination has changed. The High Court has to be consistent. Right? We hope that where do you stand in law, you understand, right? But it's your duty to argue that we appreciate.
See, Mr. Sridhar, that's why I told you in the beginning, your initial acquisition, this court directed to you to go to competent civil court. This is the second addition to that, in addition to what is already acquired. So the addition part cannot be decided by the High Court while your first original claim is pending adjudication before the competent civil court.
As on today, they have not approached the civil court, my lords. As on today, they have not approached the civil court by failing.
Yes, why should it? Don't be impatient. When court is not putting any question.
I'm sorry.
That is the main issue we are.
So, no, what? No, so what was the subsequent this thing? This was, you filed earlier writ petition when 22/7/2019 was issued to you, and you submitted an explanation on 26/7/2019 and it was demolished. Now, what is the subsequent cause of action for you to file a writ petition? Additional 10 feet notice dated. Additional 10 feet of the property without notice demolished. When? When? You know the date. 28/4/20. So therefore another petition.
They are saying that repetition, not to lay road.
They were waiting that petition to decide it.
28/4, against which this writ appeal is filed.
28, 9 September earliest previous, 9 September 19.
Yes,
Previous one.
previous.
We got it right. We have got, so
Only requesting my lord.
so additional
State
10,
has not-
additional 10 feet of land, your property, belonging to your property, without any notice, the construction raised therein has been demolished on 28/4/23. No procedure prescribed. The procedure prescribed under the which act?
Telangana Municipalities Act.
Municipalities Act, not followed. Then, therefore, you are entitled to compensation of what amount? You have to say, you are the petitioner.
Let them now initiate proceedings, my lord, under land acquisition. Pay compensation to us.
So demolished and did what?
They laid road.
Acha, laid road. Widened the road or laid road?
Widened.
Widened the road.
I am only seeking, my lord, compensation by way of acquiring our lands. Conduct an inquiry, acquire the lands, and pay compensation.
But provided you prove this thing, like your title.
At the issued notices, my lord, we would have proved our case before them.
They will make a claim and which company today that's saying it's all our land, so we will not even issue notice. And then
In that case, he would have to establish time will become. We can't ask them to initiate land acquisition to his title. Establish your title in a manner known to law. What can be done, Mr.? What's your stand, Mr.?
Opportunity.
Just a minute. Opportunity, law gives you opportunity. What is your case? You have acquired his land. I mean, you have or widening of the road without payment of compensation. Is that what you?
Land belongs to state government, my lords.
No.
With regard to the awareness made by the appellants council.
You are an encroacher. They are an encroacher.
Appellants are the encroachers, my lord. With regard to the additional 10 feet of road margin, my lord, there is no whisper about the additional 10 feet in the affidavit, my lords. They have not, nowhere in the affidavit, they have mentioned that we have occupied 10 more feet, my lords. Rashmi, kindly see
Not
that.
occupied. He says that it's my land.
There is no whisper, my lords, in the affidavit, my lords, that we have.
That's his case. You are saying that this thing.
The year 2019 itself, my lords, issue attained finality, my lords, by way of on 9/9/2019, my lords.
95 judgment, Mr.
That's 1995 supplementary 1 461. Ghana.
Passed in one. 95. Next. All right. This. Fine. How we Yes. Correct.
Let's kindly see the affidavit.
Fine. Yes.
Affidavit, page number 38, minutes.
Yes, Mr.
Nowhere they have mentioned that we have.
Correct. Fine.
Acquired.
In fact, my lord, in page 97, there is an order of the division bench of this court, my lord. Because when they were fighting the road, 97 itself, my lord, a writ petition was filed, which was taken up by the division bench of this order. I go 97J, your lordship. Material papers.
97.
97J. All these writ petitioners are now writ petitioners in the present proceedings.
So why you did not bring to the notice of the judge hearing WP 17095 that 97 I have been granted compensation and therefore you must grant me compensation. How have you suffered that order and allowed it to attain finality? Your conduct also, subject matter is different, that we understand. But in respect of, so what remains now? Nothing. You are rendered destitute or what, some part remains?
Destitute. Most of them destitute.
Okay, so you are rendered homeless. Nothing, no, all encroachment to your whole house. Okay. No, not only two of them before us. We don't.
Others, they promised that they will pay compensation.
In this writ appeal, only 2 persons.
The other writ petitions.
Fine.
Appellant council, my lords, deliberately not chosen to file our vacate stay petition, my lords, filed in the writ petition, my lords. Our vacate stay petition is not filed along with.
Let him complete, right? We will hear you. If any adverse order is going to be passed, you shall definitely be heard. We can't do this.
Next thing is
97J, second para.
No, what is this petition 97J?
For the same,
By whom?
same road, my lord, when the road was.
You are not parties to, but let us be clear.
These petitioners are parties to the present.
So how many petitions? This was another petition. What? Filed for what?
For widening of the same road.
This is the first round of widening from 30 feet to 50 feet. Now, then came the second round of widening, 50 feet to
this some 98
97 with
98.
So this widening was for from 30 feet to
50 feet.
50 in the original 97.
Yes.
Mr. Who are you?
Yes, we have filed a detailed vacate, my lords.
Who are you?
I am appearing for the respondent 124, my lords.
No, who is 124?
I am representing municipality of Suryapet municipality. Yes, my lords.
And who appears for state?
Yes. My lords, I am.
No. Appears state also.
Yes.
So what is the policy of you are this thing providing 2 BHK homes to people belonging to BPL category, correct?
My lords.
These people are destitutes. They don't have they have been rendered shelterless. So you are a welfare state, right? We are not law. We are not talking about law. As an officer of the court,
my lords.
You were very keen to argue, so we thought that we should put some questions to you. Just a minute.
And
So, no, lighter way, mister. Don't take it
No.
lighter. Yes, sir. So, these people,
my lords.
whether they are encroachers or not encroachers, compensation, we will decide that in this writ appeal. But we are asking you, these people are homeless, right?
Yes, I'll-
Let us assume, just a minute. Let us assume that they are homeless. What is your policy of providing shelter to homeless people?
2 BHK.
Policy of the state.
2 BHK scheme is there, my lords.
So in case they are entitled under 2 BHK scheme, they can apply to the committees, right? There are committees constituted which considers the claim.
Yes, my lords.
Mister, instead of laying a claim for compensation and we don't know what we will take, you understand the legal difficulty. Why don't you apply under the scheme? We have dealt with this. Special counsel was appearing. He said out of so many houses, 1 lakh so and so houses constructed in different districts. Which district you belong to? Suryapet. How many, madam, yesterday's matter was there, Suryapet. How many houses have been constructed in Suryapet? Under BHK
In this
scheme.
case, my lords, peculiarly, my lords, petitioners are the landowners, my lords.
No.
But they encroach upon the government land adjacent to their land, my lords. That has been.
Mr. This, if you want to, he said, and we believe that he will make a factually correct statement, any counsel for that matter. You say that he is telling a incorrect statement of facts, we will haul him up for contempt.
In fact,
No. Right. Conduct a survey, find out that these people are still residing in their houses.
May I submit, my lords? In fact, the one petition is died, my lords. In the name of dead person, the petition is filed, my lords. That has been narrated in my vacate state petition, my lords. That was not filed along with writ appeal, my lords. One person is died long back, my lords. In the name of dead person, a writ petition has been moved, my lords. By suppressing this 2019 order, my lords, they got interim order.
No, so therefore they are, according to you, they are not entitled to anything, right? Even the benefit of scheme
No, my lords.
floated by the state government because they are not residents of state of
I am
Telangana
not-
and they are enemy subjects. So you will hang them to death.
No, my lords, I am not.
Yes.
I am not.
You are an officer of the court,
Yes,
Mr. How
ma'am.
can you argue like this? We are not on legal issues in this appeal. Legal issue we will answer. We are something you should understand, right?
State
No, they are encroachers. You have taken action against them. Encroachment has been removed. Their houses has been demolished. If they are entitled to under any benefit under the state policy, that's what we are saying, that you should give them benefit. They will give up their claim for compensation.
my lords.
You should immediately say, yes, sir, we will examine. If they are entitled under the scheme, their case will be on. If case is recommended by the committee, they will be allotted.
Yes.
What is there to contest? You call Mr. Harendra Prasad, call him.
Yes.
It requires a bit of maturity to appear and to take a human holistic view of whole thing. It's not confined to this thing, Mr. Hmm? We don't want to say anything further. And these poor people are there. Supposing if some person in political dispensation would have encroached the land, would you have demolished with the same might? So let us assume some member of legislative assembly would have encroached the land abutting to road. Would you have opposed this like the way you are opposing his claim? That itself shows they are poor people. They can be hanged. That's why you are arguing. Oh, no, they are criminals.
No,
That
I'm not.
whatever they have done, you have taken action against them. Encroachment has been removed. The government land has been utilized for the purposes of widening of the road for a public purpose. We are not on this issue. We are on the issue. Have you sent
Yes, madam.
for Mr. Prasad?
Yes.
Mr. Prasad.
Harendra Prasad, madam. Special chief.
Prasad. Where is he? Call him.
He's coming.
He knows.
He's coming.
He knows. Otherwise, the state government for years to come will face a suit for compensation. They will file. Got it, Mr. That you lodge a claim under this to landless people, if they are really landless, we don't know. You file an application. You don't have any this thing on legally speaking on merits. You don't have a case. what we are inclined to observe, that the state has framed a policy for allotment of 2 BHK houses to people who live below poverty line and are homeless. You lodge a claim before that committee. The committee will consider your claim in accordance with law. If you are found entitled, the state government, that's why we have called the special GP, a special counsel. He will make a statement that we are sure he will make a statement that you will be allotted the land. Correct? There is nothing in your case. This is the most we can do for you.
But state cannot act in such a manner.
No, Mr. Then we
From the citizen.
correct, Mr. But see, we are ready to grant a declaration that the action of the act, this state is illegal. But determination of quantum of compensation, we will have to relegate you to the remedy of suit. Remedy of suit, you will never get anything in your lifetime. That's an assurance. Correct? Mr. 1 minute. We wanted your assistance. In this case, which you have nothing to do with. He is representing the, additional advocate general is representing, but we want your assistance. The appellants are encroachers according to state. He says that the land belongs to us. Their houses were adjacent to a land. So, the state said that they are encroachers. So, encroachment was removed in 24 hours without giving them any notice. Their houses were demolished. The councils for the appellant says that these people are below poverty line and landless people, whatever. I'm living below poverty line. We were just reminded of the fact that yesterday you argued a case saying that there is a scheme, DHK houses for persons below poverty line. So, and there is a committee which monitors the claims of the people in various districts of state of Telangana on the basis of guidelines. So, while upholding the order passed by the learned single judge, we are only inclined to observe that in case, which has nothing to do with this case, so in case he makes an application under the PHK scheme to the committee, you say that the committee will examine it, and if the committee recommends, their case will be considered for allotment. That the scheme is there to that, even that prayer was being opposed. So by him, so we thought that we will get your concession. We will appoint you as amicus, and you make a statement that, in fact, we would have been happy if it had come from him. But he's a young man, enthusiastic, wants to oppose everything. So we thought that probably we will be able to convey our concern. This appeal is being dismissed. We are not interfering with the order. But in case they make a claim, please, they are entitled, right? They are citizens of Telangana. They are entitled to benefit of this scheme. He can't deny that, no, because they had encroached, so I will kill them. They can just sort of an argument. We will not. So we will record your concession. Please. 1 minute. Yes, madam. This intra-court, Mr. All the times you have to be reasonable to the court. You always there. What can you do if they apply under this scheme? Supposing if they apply under this, we have just suggested. It should have said, yes, sir, it will be considered. Under this scheme, if they are found entitled, it will be given.
My instructions, my lord, they are not homeless persons, my lord. My instructions are there, my lord.
That committee will consider. We are not adjudicating. No, that's where you should have realized that question, whether or not they are eligible, that committee will consider. If they found that these people are rich people and have multiple houses and they have rented out the accommodation, earning money, the source of money is a rental income, it will be dismissed. That we don't have a means to adjudicate in this. It's a humanitarian approach to say the least, that to think which they are entitled to. We could have, instead of saying he will advise them. But no, that's it. Right. This intra-court appeal has been filed against an order. Right. Nothing. We are upholding the order. Yeah. The committee, yes, no? So it's not that you can do both the things, file a suit also if you so choose or for the scheme. Choice is yours. We are not saying. Yes, mister. They can file a suit for compensation which they will establish title and go. That's what single judge has said. So they have not filed any appeal against that order. So that part of the direction we will not disturb. In addition, we will say that it will be open for them to apply under the scheme as well. Because they have not filed any appeal against this order granting liberty to them to file civil suit seeking compensation. Right? This intra-court appeal has been filed against an order dated
Which page, relevant page is that? Type the copy. 7J.
No,
J.
there I saw. There is that order. We gave this other. Where is that one? Yes. Other order you just now gave.
17095.
Here it's. This. Paragraph. Yes, madam. Facts leading to filing of this
Minutes.
After the
Well, that's my-
disposal of the earlier writ petitions, 10 feet was marked. Challenging that, I filed writ petition 21913, challenging that act.
That further 10
Stay
feet
was
is-
granted.
No, there is-
Thereafter, on 28/4/2023, this writ petition was dismissed. On the very same day, they have done.
Delete, madam, that para. Now, what para? This. Delete this para. Delete.
Obliged minutes.
No, we detained you for this, for them. Thank you. Call this probably is one. So next case, same matter, huh? Any confusion, please show. Yes.
GP for services 1 and 3.
Yes.
Sir, I'm appearing for respondents 1, 2, 3.
Counter.
I take an objection about the maintainability of the writ petition without first approaching the Central Administrative Tribunal, my lord, as said by the Supreme Court in Chandra Kumar's case. High Court is not the first court in service matters. You should necessarily approach the Central Administrative Tribunal.
Ready,
Then come here.
ready with this objection? No, ready, then we will hear you. Are you ready to make this objection? You want time to address us? Learned, you are
My lord, I am the special counsel for the state of Andhra.
learned counsel for special counsel for state of Andhra Pradesh submits that
The petition before lordship is an employment into the notification.
contempt,
Contempt and restriction.
Counter.
APPSC,
Public Service Commission.
TSPSC and APPSC. Main grievance are against APPSC.
For re-examination. They have not sent to you for re-examination of your height so far. Then the issue notice has not been issued.
Notice has been.
Gopal's Telangana Public Service Commission.
They have been served, right?
Petition bundle.
I am for third respondent.
Huh?
I represent third
Hey,
respondent.
Mr. Contempt petition, who are respondents?
APPSC, Mira. Secretary APPS, Andhra Pradesh Public Service Commission.
Andhra Pradesh, his name, right? You can't implead in a contempt petition secretary is so and so.
Okay. Sorry, sorry.
You amend the cost title. Contempt, he has to learn it counsel for the petitioner praise for and is granted.
2 weeks.
2 weeks time.
Lordship directed me to amend the preamble. I am filing today, Lord. I have next week.
What twice it is listed, right? Learned counsel for the petitioner once again prays for adjournment to enable him to file an application in the light of liberty granted to him on 31/7/23 list after 1 week.
Request 4 weeks time.
My lord, petition filed challenging regulations of the National Medical Commission with respect to qualification of teachers.
You don't want
Has
to
been
file.
filed.
Request 4 weeks time.
Who are you?
I am respondent number 1, representing respondent.
One.
One respondent number 1.
Speak into the mic. Why you are? Learned counsel for respondent number 1, praise fund is granted 4 weeks time to enable him to file counter. See, petition is admitted for hearing, you say. None for the petitioner, admitted for hearing, 4 weeks time. There is no interim order, madam.
No, it's no interim.
Yes. Hmm. Hmm. Yes.
But in the extended 23.
Counter has been filed, right?
Yes, sir. Counter is fine.
Then it has to be heard, right? Validity of rules.
Rule, madam.
Petition is admitted for hearing.
And next matter.
You want to file any rejoinder?
Rejoinder is also filed.
But pleadings in the case are complete, petition is admitted for hearing.
The next matter, the connected blood when no count is high.
Which case?
Next case, 23rd item.
23rd, yes.
2 weeks.
Admitted for hearing, list for analogous hearing along with WP number 44365/2022. Let counter, if any, be filed within a period of 3 weeks.
Obliged.
Next.
Oh, counter affidavit is fine. I guess the price.
Admitted for hearing, let counter, if any, on behalf of respondents be filed within a period of 6 weeks. Just stop construction. Mr. Which provision, section 7?
7. Presenting for
Section 7 to stop construction or to direct an inquiry to stop construct, what?
It is with regard to the survey problem, my lord.
Then you shouldn't interfere, right? How can you issue a direction to stop construction?
Till
What?
finalization of survey.
You can't do it. You are not a revenue officer. Are you? Revenue officer directing to stop survey. Who appears for response?
I'm for respondent number 4, my lords. Respondent number 4, my lords.
You had gone there, no? So you are standing quietly as if you are for the petitioner. Yeah. It's good idea to stand here to avoid questions of court. So whosoever appears this side will face. Good idea.
Actually,
Our association always young members have bright ideas. We appreciate this.
Yes, my lords. My senior actually wants to argue this matter before.
Nothing, you senior, you are senior counsel. We will designate you as senior counsel in next full court meeting. Argue. For that you must begin arguing. So which provision of Lokayukt Act he has? See and tell us, where does he get jurisdiction to stop construction? Which act? What will give it, Mr. Counsel? Tell. He wants to become a senior advocate, so you must, right? Which provision?
Section 7, my lords.
Where is the order of this thing? Read it. Where is the provision enabling this to stop construction? He can inquire into the complaints relating to construction also. Which clause?
Your lordship permits, I shall just read all entire matter.
Don't matter. Read which clause permits him to conduct an inquiry. Supposing if he has to power to conduct, listen here, Mister. Don't look at him. If Lokayukt has power to conduct an inquiry with regard to any construction made, we will agree with your submission that he has power to grant stay, because that is an ancillary power. So you go through it and tell us which clause, which subsection permits him to make a complaint with inquire into this construction raised by anybody. They all will be happy. They will all abolish your offices, right, to regulate construction. Lokayukt will do it. All constructions, all across state of Telangana, he is the authority. You tell me this thing. This thing. So, Mr. Which
My
clause?
notes, clause number 4, I will just read out clause number 4, my notes. That is,
4 of 7.
Clause 7.
yes,
one
yes, my
four.
notes. Section 7, clause 4, where 2 or more Upalokayuktas are appointed under this act, the Lokayukta may by general or special order assign to each of them matters which may be investigated by them under this act, provided that no investigation made by Upalokayukta.
No, what did we ask you? He should have a power to make investigation with regard to construction. Then only he can pass an order. What do you say, Mister? After perusal of the act, what do you say? Power is there, not there. There can't be.
Page
You cannot argue that it's there.
only we have ordered for investigation, my lord. Till investigation, construction shall be
It can't.
stopped, my lord.
You ordered investigation. The Tahsildar goes and gives a letter saying to your authorities give a letter, stop constructions.
No, in the order it is there, not to stop the construction.
In order.
No, Mister.
Page 14.
See, this is not correct. No ordered investigation. At least all the time, page 13, last line. Read it aloud. Read it. Right? Page 13 is your order.
Yes.
What does it say last line?
Yes.
No, read it. Read that aloud.
Till such time, no structures shall be allowed to rise.
How you are saying that I only said investigate. And you will have power to investigate in respect of a subject matter covered under section 7. Not anything. No, supposing if he says that my relative has died on account of medical negligence on a treatment given by doctor. You will say, I will conduct an inquiry till then he be put behind bars. License be, or not behind bars, license be suspended, he cannot practice. I am holding an inquiry. You understand, Mister? If you don't, as a lawyer, you have to assist all the time. No power. So nothing, no senior. No power, no senior. You are senior, right? Give your biodata to the registrar judicial, right? Name and this thing, income, everything. We will consider designation senior counsel. You have argued it so well. What to do? You are what? Not appearing.
Respond number 3, Milord. I am appearing for response.
Nothing to do with this.
Municipal corporation, as per the directions of the Lokayukta, Milord, they have issued notice to the petitioner to stop the construction.
This thing is based on Lokayukta. You have nothing to do. But why don't you examine his grievance with regard to construction if he has?
Permission is.
Grant you the liberty to approach Greater Warangal Municipal Corporation with regard to your grievance, and he assures that he will look into it. Correct? In this writ petition under Article 226 of the Yes.
Item 2016.
Last note.
Statement also for petition 2025 divided.
Counter, counter.
Lord, short time may be granted.
How much time? Don't, I mean, you are granted short time, don't this thing. Earlier also you were granted time.
Lord, the first
The
time.
short accommodation, earlier also you were granted an 11.8,
No, on 27.
27.7.
Yes,
You said the same thing, short accommodation.
Lordship, Lord, this is regarding.
We know what is it about, how much time?
4 weeks.
Let them, this. Learn medical reimbursement to the extent you have actually incurred the amount. It is limited by rules to 1 lakh. Yes.
That
They
remains
understand,
balance-
right?
Claiming for the balance of.
Ah.
Balance of.
So that is what is you are entitled to, madam. That's what the main relief. We can't grant it today in the absence of counter. So and so. By way of indulgence, praise for is granted 4 weeks time to enable him to file counter. It is made clear in case counter is not filed on or before next date of hearing, appropriate order shall be passed. List after 4 weeks. Yes. Mr. Counsel, you should come up on the next date with the GO instead of resisting that they are entitled to, right?
Lord, I want.
Ah.
GO is right now with me, my lord. Only all that is I wanted to file a short counter, my lord.
GO is with you, then why are you not producing it?
GO is there, my lord, but their stand is on the same day, my lord, I have addressed a letter to the department stating that
GO is there means granting their claim.
it is restricted, my lord. The earlier it
That
was.
is the challenge. The GFC has filed with the petition. What is there with you?
Policy lordships asked me in previous section.
Therefore, instead of contesting it, advise the government. Yes.
So I'm appearing for the petitioner, my lord, in this matter.
Moved an application to receive the additional document. These are all subsequent events. After filing the counter petition, I was considering filing. To receive the additional document.
That will be received at the time of hearing. Orders on IA, which IA? 1 of 2023 shall be passed at the time of hearing of the writ petition. You want to file any rejoinder?
Not a rejoinder, my lord. The pollution control board has not come up with a counter affidavit, my lord.
They are not they said that they have filed everything. We cannot compel. That's a matter to be heard at the time of. What is the grievance?
The grievance of the petitioner says, my lord, this has been, writ petition has been moved by way of public interest litigation.
That we know. What is the subject matter?
The subject
promotion being passed.
Yes, my lord.
Have you approached them?
We have approached them, my lord, by way of several representations which are filed.
R4 to R8 are conducting quarrying operations illegally. Since when?
R8.
When?
From the date of issuance of their.
When? That is obviously.
2017, my lord.
2017.
But immediately I have filed, my lord, I have given my representations. Thereafter, I have filed my
Quarrying operation is till what time? When it license.
period was for a period of 15 years, my lord.
50 years.
15, 1-5.
1-5. Okay. Petition is admitted for hearing. Pleadings in the case are complete. The same is a petition is admitted for hearing. This IA whatever 1 of 23 shall be considered at the time of hearing of the appeal. Yes, Mr. Now have we got the chart?
Yes, sir. I have also filed a detailed chart for registry, Millard. Have it on Monday, Millard, for detailed.
What, Mr. One day we will adjourn for his chart, another day for your chart. You give it.
With substantial metal papers, I have filed before registry, Millard. Lordship, end of the list, Millard.
End of the list, 15 minutes.
I'm sorry.
Or we can sit for additional 10 minutes for you.
Monday. On Monday. Because the ground report also.
You don't have a copy. You can give it to us, copy.
Copy. We will call also, but you can give us in the meanwhile, one copy also you give, we will share.
I'll end up the list.
End of the list.
End of the list is 1:30.
So I have it on Monday, we'll have the detail.
Arey, Mr. Prabhakar, you should have compassion for flood victims.
Yeah, yeah.
Getting delayed, right?
So that my lord, with the substantial medical papers along with the reports I have filed for kind consideration of some.
You have got the copy? No. Give it.
Tabulated.
What is substantial reports?
Not his report, sir. State paper report.
No. Has he given copy to you? Or
Just have given in your office, which you are of which obviously not aware.
copy? Again, Monday what happens? He will say, Mr. Prabhakar is giving some copy now.
After lunch, I will submit remarks.
Just tabulated.
Yes.
Yeah, read this.
Please.
The notes from the about the IMD warnings. First paragraph is IMD warnings. Issued. Your Lordship, respectfully submitted the state of Telangana experienced heavy rains from 18 to 27 July. As per Indian Meteorological Department, intimated all forecasting extremely heavy rains on 19th and 20th of and later from 26 to 28. The situation aggravated due to heavy rains in coastal Maharashtra, catchment areas of river Godavari and its tributaries Maharashtra. The state witnessed continuous heavy rainfall, causing flooding in low-lying areas, breaches to irrigation tanks, damage to roads and agricultural crops, which led to loss of 49 lives and severe damage to irrigation tanks. But thereafter, I put it in the tabulated form, the preparedness of the state. The government has set up robust weather stations in Telangana State Development Planning Society to monitor the weather data and provide hourly information to state, district and mandal level administration. The regular data enable the state and district administration to take precautionary actions as below. Based on the forecast from IMD and TSDPS was issued daily forecast and timely alerts to the entire state administration. State provided 10 NDRF teams and deployed 2 helicopters in critical locations. Along with the support of the IAF, Indian Air Force and NDRF, the local police and the state fire and emergency department were in vulnerable locations for rescue and relief. Holidays were declared. This was also part of the earlier report. Holidays were declared on 19th and 20th of July. Again, 26th to 28th of July as precautionary measures. The Lordship then turned to page 2. The district administration identified shelter locations and necessary stay food, medical support and water were made available to the flood relief centers. During this disaster, district administration coordinating with IAF, NDRF and fire and disaster response department have evacuated people from inundated areas. 7 special officers were deployed at respective flood affected districts from the state headquarters to strengthen the hands of the district administration with the experience. 24/7 control room incident response command system was set up at Telangana Secretariat, and real-time instructions and support was extended to all districts. A total of 177 relief shelters were set up and operated to meet the needs of 11,748 persons. The post-disaster is identification of deaths and extension of financial support under SDRF guidelines initiated. Also for casualties, an assessment of damages and losses as per SDRF guidelines have been initiated and likely to submit the report for seeking assistance from the Government of India under SDRF and NDRF guidelines. Damage to roads, electric poles are being restored on war footing. Restore power and connectivity. Medical camp provided for flood victims. Respectfully submit Honorable Court orders dated 2/8/23 as directed the state government to appraise this court regard to the measures action taken by the state. The number of deaths in Jaishankar Bhupalpalli were reported were 4. The steps taken to identify the flood victims. For effective flood relief measures in identifying the flood victims and evacuation were possible by deploying personnel of NDRF to IF helicopters and 27 boats. In Jaishankar Bhupalpalli district, the district administration coordinated with IAF, NDRF police, Fire and Disaster Response Department and other authorities evacuated 655 people. A total of 177 relief shelters in the entire state were set up with essential goods, food and medical facilities. But this was also read earlier. The process is underway to identify persons who are impacted by floods, which will be ongoing process with the support of local officials for the verification of damages to the houses. Then after, all the authorities have taken measures to the support of center, state and regional level coordinated forces.
What will you say, Mr. Prabhakar?
4 lakhs of
Check every direction of this honorable court, Miller.
Has not been complied with. They have not done anything on the ground.
Yes, sir. Each and every substantial material paper I have enclosed in my material papers, Miller. And
This is not, let it not be an occasion to accuse government. They are doing something, right? You can't say they have not done anything.
categorically stated they were also party before the Honorable Supreme Court and filed by counter also. And a single guidelines of the Honorable Supreme Court has not been complied for 10 days, with 19th July to 30th July, even after direction of this.
No, so 1 minute. So supposing if your submission is accepted, what should we do? Not complied for 10 days. And just supposing.
Yes.
What the next stage? This is what to suggest. This is PIL, not a ground to fight against the government.
Yes.
Not a forum.
Yes.
You want to fight it? Go to the streets. Carry demonstration, procession, whatever you. The court won't. So they did not do anything. So what?
So
therefore, no right to continue in office. What is this?
Lordships, my humble submission with respect to this honorable court. Some more time may be given to them to comply the orders of.
Yes, got it. Yes, got it. Mr. We have been telling everyone in a public interest litigation, your approach has to be different. You have to see what all has been done, what else is required to be done. We are sitting here to ensure that they do their task and provide effective relief to flood victims. But first of all, you will have to stop accusing. You have to tell us by way of a chart, this is all what is required to be done for
your lordship.
This is what else is required to be done for flood victims now. The relief has not been extended. Whatever these are the beneficiaries.
Yes.
That's what we will ensure that we will take them to task.
It's on this honorable court that Millard could ensure the same. Kindly have it on Monday, Millard. The substantial material paper I have submitted before your lordship.
What substantial material papers?
Lordships.
So, Mr. List of, so some details you need to furnish, right? See, you have said that you are identifying the people, right, of flood victims. How many people have you identified? Ex gratia amount of 4 lakhs.
4 lakhs is the
details.
Number of details.
Monday.
Wednesday, brother, since because of the
then Wednesday he will file another material paper. So then, Mr. Prabhakar.
One item may I submit, Millard?
fairly state because of the
consecutive
Independence Day
going down huge epidemic disease, Millard. That's also is not being controlled by the state.
Which epidemic disease?
Consecutive ice. Conjunctivitis.
Conjunctivitis.
Yes.
So that is
serious steps are being taken. It's a very big hospital in Hyderabad.
Taken, not submitted before this.
How many patients? How many people are suffering from conjunctivitis in flooded?
Lakhs of people and lakhs of students are being infected. Not only disaster affected area, including Hyderabad city also.
No. One of the honorable judges of this court also suffered from conjunctivitis. Do you mean to say he is this thing flood victim? What is this, Mr.? Anybody, conjunctivitis can happen due to this heavy weather. No sun. Anybody can so you can say COVID is happening there. COVID is happening to flood. This can happen to you also here.
I am sufficient.
Mr. Please don't make this thing sweeping allegations without any material. You are also accountable to this court in a public interest.
Yes.
We are saying that it's a
Responsible to.
it's a genuine public interest litigation. We are saying so.
Yes.
But don't say lakhs of people, crores of people.
No, my lord, I'm submitting with substantial material.
We are thankful to you. Where is you are just making submission orally.
Lordships,
He doesn't know what you are talking about.
Lordships, I will have Monday without with substantial material paper I will submit, my lord.
We are not closing it.
Malaria also are being infected.
See,
Disaster areas.
epidemic on account of floods would be malaria.
Yes.
What are the measures that you should say conjunctivitis in Hyderabad? How are we concerned?
No. Hyderabad, even in
Prabhakar, that
area also you are not
don't
may
you see
find
the
them.
process addressing unconcerned issues, the relevant issues
Are lost.
Yes.
Then we feel that you are not serious about this PIL and flood. You want forum to attack the government.
No.
Well, it is not.
I'm only
Will
in the interest of public.
It's not. Also, that's why focus on these people. No, Mister, you keep on talking about this thing conjunctivitis in Hyderabad. People, Hyderabad floods have not come.
With great examples.
No, great risk. In the light of direction,
I have brought before your lordship that
we are not closing this PIL. It can't be done. Right? We are asking him to furnish more particulars. It can't be closed. What do you think that we will just now, without hearing you, without your going through your application, will close this PIL? It can't be. It has to be there in action or whatever. We will monitor. We will see to it that they do it, whatever is required. He is not contesting. The problem is that you want to fight against a person who is not contesting. He says that I am willing to do. He is telling us, please tell us what to do. You are interested in fighting against him.
No, my lord, I have already written in my suggestions, my lord, that what needs to be done.
Therefore, all constructive suggestions are welcome. We will do it. Yes.
At page 10 and 15, I have categorical stated.
In compliance of the directions contained in the orders. Toll number you have given.
Toll number I have given.
Restoration, essential services restored.
And the roads which we have been.
Cancelling you have done.
Yes.
According to you. Epidemic diseases, what action?
Epidemic disease,
what action you have taken? I don't, we don't think that in the chart you have mentioned.
In the Roman 6, if you lordship.
Paragraph.
Roman 6.
We have perused the chart produced by the office is directed to trace the
Pardon me, Milord.
trace the memo and place it on record. Yes.
All are very good people.
Yes. 29.
But in item 29, my lord, I'm appearing for respondent 3, 5 and 6. We have filed a status report complying with the directions of this honorable court. Along with the status report, we filed the seizure notice, my lord. The temple which is, the disputed temple is now seized under section 461A of GHMC Act.
Why?
It was an encroachment, my lord. The temple was, they have constructed an unauthorized structure.
Unauthorized construction has been accepted. And in that, they have been constructed.
Your grievance stands redressed.
No, my lord, that construction is there, that has to be demolished.
So then what do you do next?
That has to be demolished.
It's a very sensitive issue, my lord. We have seized that property under 461A. After
Waiting
issuing,
for directions of this.
yes, with your lordships. Page number 10, your lordship will file the seizure.
You, Mr. C,
It has to be.
the report placed by counsel for GHMC stating that the temple in question was being constructed unauthorizedly and the same has been seized by
Yes, respondent 3, 5 and 6.
in exercise of powers under
461A of GHMC
Act, right? The aforesaid status is taken on record, list after 3 weeks.
It has to be demolished unless there is a direction.
We need to hear it's 1:35. See the time. That's why we have said after 3 weeks.
Your lordship.
They have made some progress, right?
2 weeks may be granted. 2 weeks.
Your lordship, item number
How
30.
many are authorized structures in the state? Find out how many.
Your lordship, item number 30, your lordship, representing for respondent number 2, 3, 4, 6 and 7.
2, 3, 4, 6,
6 and
7
7.
case warrant is
3
granted.
weeks time for counter hearing.
4 weeks time to file count.
Oh, bless me.
May I say, your lordship? I'm representing the petitioners.
This matter may not, affidavit is served on me, no?
We have passed an order on
Yes,
11.
my
It's
lordship.
why it has come now?
Last occasion, my lord, your lordship directed the Lake Protection Committee. Lake Protection Committee to
Where is the council is not there?
I am appealing for the Lake Protection Committee, my lords.
Right, but you are the council not smiling. The Lake Protection Committee council used to smile. That's how we remember. Correct?
Yes, my lord.
He is not smiling. Why?
That is my senior.
He was your senior. So you should. Where is that?
I filed affidavit 7598720.
No, Mr. Notifying the buffer zone for existing water bodies. Where is the notification?
I filed an affidavit.
Have you done it? Not done it?
No, we have done it, my lordship. The effort is being made. Your lordship will see. I have given a tabular form where, with regard to lakes, my lords, the identification of lakes is a continuous process, my lords. Lordship will see kindly. Lordship, take the affidavit.
No, are you required, Mr. Again, you have started arguing. We are asking you simple thing. Have you notified the buffer zone of existing water bodies in the limits of HMDA? The answer is yes or no.
Yes, to the extent of 230 lakes, my lords.
Then say so.
Yes.
You are saying I am giving chart and all that. What chart?
Sorry.
Chart of non-compliance, right? Then say so. First sentence should be that I have complied with the directions contained partially. There are so many lakes, out of them, this much I have notified. How many lakes in HMDA limits?
As on today, my lord, there are about 3,532 lakes.
3,500?
32 lakes. And there's
In HMDA limits. So it has to be preserved at all costs, right?
Yes.
So then how many have you notified?
Preliminary notification has been done for 2497, my lords.
What preliminary notification? It's a land acquisition thing, preliminary notification, final notification, under which law preliminary notification have you done?
The Lake Protection Committee was constituted through a.
We are not asking about constitution. You said I have issued preliminary notification under which provision of the act?
CO 157.
GOMS.
There's no provision of law. There's no Lake Authorities Act or Tank Development Act in Karnataka, in Hyderabad.
May I make a submission, my lordship? May I make a
Make a submission only to assist, not to complicate. Which provision preliminary notification?
GOMS number 157, which has been issued basis on the orders of this Honorable High Court, a Lake Protection Committee has been formed. GHMC Commission.
It's not an order from the court. Lake Protection Committee constituted.
Lake Protection Committee has been formed by GOMS number 157 dated 6/4/2020.
157
in compliance with
Just
the
a
order.
minute. We are writing, Mr.
Macho, sorry.
It's very easy to.
My apologies.
We are not stenographers, right? So that we
My
can.
apologies.
So GOMS number 157 of 20.
Yes, my lordship.
Then-
2010.
2010, 2020 you said.
6/4/2010. 6th April 2010, my lordship.
So GOMS is 157 of 2010.
Yes, my lordship.
That Lake
This is-
Committee constituted.
Yes, this
So
is
under
from-
which provision they have issued a preliminary
Absolutely.
notification?
In fact, my lordship, if we see this GOMS number 157, it only states about listing of lakes. In fact, they have
So that's
irrigation.
why we understand that it's a preliminary notification is incorrect.
Yes, my lordship. It is incorrect. In fact, the irrigation department has got the lake memoirs. They have every data of the lake.
So this thing, buffer zone is provided in respect of each
Yes, my
listing lake, and that is Mantri developers Supreme Court.
Absolutely, my lordship. Yes, yes. my
Mantri developers, Mantri tech zone. So this all submission that it's a preliminary notification and then inviting people to meet them alone and then dropping in final notification
Yes, my
from lakes, this all.
It is all about
Correct,
encouraging.
right?
Yes, absolutely, my lordship. In fact, in Mantri's notification, I was also there in
Mr.
Bangalore.
Which provision of law preliminary notification of lake inviting people come and meet our officers privately?
No.
Huh?
My lordship,
This is all we understand, Mr. These tactics. Don't.
No.
Which authority? You will file an affidavit stating that under which authority you have issued a preliminary notification.
Lordship, may kindly see.
When there was a direction to notify the buffer zone. Well, how come you have issued a preliminary notification? This is violation of the order. Who heads the committee?
Commissioner GHMC.
Commissioner? What?
GHMC.
Huh?
GHMC.
Member convener is the person who is filed the affidavit, my lords. Member environment is part of the committee, my lords.
No, Commissioner GHMC heads the committee. He is responsible.
R9 is the chairman of the Lake
Which-
Protection Committee.
Thrice we told you, asked you, you are not answering. That which provision of law he has issued a preliminary notification when there is an order passed by this court which was attended to by your senior, but you should notify the buffer zone of all the existing lakes. What preliminary notification? This is not Land Acquisition Act. 1894 notification under section 4, inviting objection, then declaration under section 6, and thereafter you will pass an award.
My lordship, as per GOMS 157, my lords. Lordship, may kindly take.
Mr. Does it provide for GOMHS?
I'll
Just a minute, you don't know. We are asking him, does it provide for preliminary notification?
No, my lords. The language is absolutely
Well,
clear.
I'll
Listing.
Where is your notification?
file an affidavit to
Where is your notification? Preliminary notification. Which page?
There are about, I have not filed preliminary, there are about 2,497 lakes, my lords.
I know, how are you telling us that preliminary notification? Mr. This, you have to issue a notification indicating the buffer zone of lakes. How can you, what is preliminary?
My lordship, I'll file an affidavit to the extent explaining everything, my lordship. Lordship may grant us some time.
Explaining everything? What? I will explain. He will appear and explain. Which under, we will ask him, Mantri Tech Zone, is he not entitled to notify? And what is this preliminary instead of you explaining, because you don't understand. But what is preliminary notification?
I will file an affidavit to the.
No.
Kindly.
You understand. Did you even understand what are you submitting?
My lordship, preliminary, may I?
You said yes or no?
My lordship, GO 157, my lords, we have acted in accordance with GO 157.
Nonsense.
Notification department. It is all notified. Yeah. These are all minor or major irrigation tax. They were all under these times, there was the cultivation that was done since maybe city has developed in last 20 years, but all these are agriculture tax.
Yes.
Okay. Now these are all minor irrigation tanks in the respective this thing covered by your Panchayat Raj department and the irrigation department. Basically, it is, they are all will be under irrigation department. In fact, I gave you a clue also. Go to one book called The Lakes of City, Hyderabad. 100 Lakes of City or the title, where you get everything, FTL, buffer zone, everything. Your HMDA authorities are not talking to irrigation department. If you get to ask them what did you do geotagging? If you are saying you have not, then how did you do geotagging of all the lakes? You claim on the other hand you have done geotagging for all the lakes. How did you do it? Without knowing the buffer zone, without knowing FTL? That's why I'm saying there is a, earlier all these tanks, they're all part of Rangareddy or other village.
Ask them to, you will ask him to produce an interpretation. We are giving you benefit of doubt. You, on the next date, you file an affidavit saying that the directions issued by us on this thing,
27 July.
27 have been complied with. In case not complied, it's a contempt. The consequences will follow. Perhaps you are not realizing what you are saying. Right? There is nothing concept preliminary notification. But still, for your inexperience and youth, we don't want to punish Commissioner GMC. Therefore, we are giving you an opportunity to explain by way of an affidavit how this order directions have been complied with and how many lakes you have notified. We were recording your oral submissions. Mark the presence. This code by an order dated 27 July 2023.
Public holidays, my lords.
They have to work extra time.
My lordship, my humble, one more thing. Please, one more thing.
The order is passed, it is open to challenge in SLP.
My lordship, there is.
Make them work. It's a question of future generation, not for us. We don't go for boating in the lakes. What you have been doing since 2010, they will land in trouble, mister. As an officer of the court, you must realize, don't make an attempt all the time to protect the persons who are inefficient and don't want to work and want to enjoy holidays. You tell them, it's as an officer of the court, your duty is to bring the order to their notice. If they don't comply, why are you pleading like a beggar on their behalf? They will face the music, right? You say that despite my instruction, they have not complied with. We will deal with it.
My lords,
We don't need your assistance. Right?
my lords,
If they don't listen to you, don't you communicate. You do your duty by communicating that I had made a prayer that it would be taken up next year on 24th December. Court did not agree. Tell them I tried my best that I wanted 8 months time so that you can go home early and enjoy your life, but court refused. Well then, should we record it? Then this is a public cause. Don't fight it like a personal interest litigation. This is for future generations to come. Repeatedly we are telling. We don't go for boating. We don't have time. I haven't seen any water body in Hyderabad. Oh, see, the council has come. You should have come early. He's facing the heat, saying for adjournment. We will tell you the order we have passed. Next.
my lords, there is a second order also in that. There are two directions. The second direction is GHMC commissioner has
coming up.
Come together.
GHMC, what?
The file are counter.
Okay. You know what your friend is trying to tell. Not do. Otherwise, you will also.
No, affidavit undertaking has to be given by GHMC commissioner for unauthorized constructions, which has not been done.
You understand, right? Better comply, otherwise.
Items 32 to 35.
He will be here then in that case.
Much obliged.
What, 32, 35?
Declaration of progression.
Right, please.
I'm up to Also, counter has been filed.
Counter filed.
You have pleadings are complete.
Yes, Your Honor.
Pleadings in the case are complete. Petition is admitted for you.
Item 36 and 37 D. Narendra Nayak, Additional Advocate General.
Ah, yes. Yes, Mr. Pleadings are complete.
Pleadings are complete.
All right. What is the validity of rule minor mineral?
Rules are under challenge.
Last date it submitted. Additional.
All right, so
Moved on.
yes. So we'll admit it.
Any short date notice?
What short?
No, that means lots of it posted today for nothing. Because
Synopsis, 2 pages, facts, submissions, case law. 2 pages if you want. Every case can't be heard in motion hearing. You will agree. There is no justification. Yesterday, 2005 matter writ appeal we reserved. The persons have retired. One of them terminated, serving on 1,500 rupees per month. They are claiming UGC pay scales. Every cause is important. What's the justification? Your client is a industry, can afford this thing, litigation.
the rules have been amended, my lord, without jurisdiction, without legislative competence.
In order to enable us to take up the matter, give a brief note on facts, submission thereafter, case law. And if you want it, we are telling you, giving hint to everybody, whosoever wants to, this thing want us, we are willing to decide cases in motion stage, but not that we will take up this case. You will argue for 1.5 hours, he will argue for 3 hours, then you will reply for 1 hour. 10 minutes flat. If you want to conclude, then if you have a confidence in your case, then file an application for urgent hearing, admitted for hearing. We'll consider. And you say that I undertake to conclude within 10 minutes, then only we will allow.
Definitely.
Ah, yes.
Item 38, conscious about taking.
Oblate. Yes.
I filed my counter in this matter.
Counter. Yes, madam.
The matter pertains to encounter lordship,
Encounter.
2 days back, they filed counter lodge. My senior.
Encounter or counter? Counter in
2 days back, they filed counter lodgeship.
All right. We thought a matter pertains to encounter.
Matter pertains to encounter.
Encounter. So when we heard correctly.
That's why I said it is counter in encounter.
Counter in encounter.
Yes, we file our counter.
So then, madam, you want to listen?
Lordship, senior will argue this matter lordship. Grant weeks of time.
Oh, where is the order like of remand by Honorable Supreme Court? Mr. 38.
This is some other matter, madam, the PUCL matter, Bombay matter, not this court. In this court, where in this case, where is the remand order from the Honorable Supreme Court?
Lordship,
No, why we are asking you? Because under the heading it is listed on remand from Supreme Court. So we want to see what is the order of remand. Mr. Yes, what happened to your civil appeal 8082 of 22?
It's full of minutes.
When? That's equal. There must be, in that order, there must be a direction or something.
But the challenge to the
Learned counsel for the parties pray for adjournment. Yes, madam. Huh? Which case, madam? Out of list. This very bench. Hmm. All right, next Friday.
Special bench page number 11, which property is the forest.
Which one? Yes.
May it please your lordships.
133.
May it please your lordships. But I am appearing for the 8th respondent in the first writ petition. That may not survive now. But the complaint was, I am appearing for the industry, matter arises under the pollution laws. I appear for the industry, my lord. The complaint in the writ petition was that I was operating without permission and the very existence of the industry in that area will hazardous is what their contention. But however, my lord, pursuant to the application made by the petition in 2016 for grant of renewal of lease license, my lord, the industry has been closed, not functioning as on today. The second writ petition, my lord.
Renewal has not been granted to you.
That was rejected on 19/7/23.
Who appears for petitioner?
In the first writ petition, I am for the second. I am in the second.
No, you first petitioner, you are the petitioner.
I am the respondent number 8.
We want to know from the petitioner. Obviously, you will say that it is infructuous. Nobody.
Respondent number 8.
None for the petitioner. Hmm.
May I narrate few facts, my lord?
No. Here. So you are not carrying out any mining operations?
Yes, my lord. Even the
this renewal has not been granted?
Yes.
All right.
The second writ petition.
Fine. We'll first deal with it, come to
Yes,
second
I'm
later.
good. I'm good.
Mark the presence, none for the petitioner. Mark their presence for learned counsel for Is here? Not here. Okay. What do we say? None. None for the petitioner, right? Ah. What?
My lord, insofar as the second petition is concerned, my lord, by an order dated 19/7/23, my lord, the State Environmental Impact Assessment Authority rejects the permission only on the ground that the Google Maps show the entire land given on lease for mining is covered under the forest, reserve forest. But the forest department themselves have granted clearance, my lord, which was placed before the authority also. Then, my lord, on 19/7 itself, we made an application saying that this area, my lord, 20 years ago, the license was granted and this is a renewal, and the authorities have given various, all authorities have given permission.
So, Mr. In previous, this is what we have disposed of his petition, and now you are challenging that.
That's why I wanted to narrate the facts, my lord. I took leave of the court to narrate the facts.
Not carrying out any so and so, and further submits that he shall carry out quarrying operations only if the permission is so they have to respond, right?
Respond, my lord. Last occasion they had taken back.
Google Map. So, you want to file, don't want to file?
We want to file counter.
How much? Again, this is not by invitation. Repeatedly, we are telling you. We shouldn't distribute print invitation cards and ask whether don't want to file. We will say all of them standing, not saying anything. And therefore, petition is allowed. Averments made in the petition are taken to be this thing corrected in the absence of any counter. Therefore, petition allowed.
My learned friend is appearing there for the authority which has passed the impugned order. My respondent number 4, State Environmental Impact Assessment Authority. I would like to bring to my lord's notice that the time period of the authority has lapsed, my lord. So I need to take instructions for constitution of new authority, my lord. The members, the tenure, my lord, has expired. So I need to take instructions regarding that as well, my lord. I need to bring it to the notice of my lord that the authority does not exist anymore.
So,
as it stands.
Who wants to file a counter? Nobody.
No,
Learned counsel for respondent number 4. Learned counsel for respondent number 4. Prays for adjournment to enable him to
take instructions, my lord.
Seek instructions about the existence of state environmental impact assessment. How does it, supposing it consists of A, B, and C? Now, D, A, E, and F are members. That you will say that the authority does not exist.
I'm so sorry, my lord. I stand corrected, my
You don't, Mr. Most of the times you are not clear about what you are saying.
I'm so sorry, my lord.
Just now you saw that the pre-lunch period, one council said that we have issued a preliminary notification. He did not realize what is preliminary notification, notifying the this thing, buffer zone of tanks. We asked him which provision. He said preliminary notification. This is what you are doing.
I'm so sorry.
You don't understand what you are saying. Merely because it is reconstituted, that doesn't mean that. Please advise the young man, Mr. Counsel, you have some experience. Please advise him that he should make such submissions, right? Tell him, offer him over a cup of coffee, tell him it's a weekend also that he shouldn't make such submissions before the courts and waste our time. Which is precious. And in any case, the whole thing is unproductive. Why? Because it's being adjourned. It's not that we are devoting time to do something. These people don't say how much time they want. It's still 5 minutes. So despite this is not invitation. You know, Mr. You appear before.
Yes, ma'am.
Why are you not saying I appear for R3 2 weeks time, 3 weeks time?
Yes.
Not saying.
I'm concerned with the first respondent.
You say I don't want to. I'm not a contesting respondent.
No,
I don't want to sign.
I'm the contesting, not I seek the 2 weeks time.
I means no, again you are not telling.
Respondent number 1, state, principal secretary.
Simple, right? Again, process of.
I seek 2 weeks.
No, we will not do it, Mr. Repeatedly, it has been over 10 days, now 3 weeks. Now, bar knows be sufficiently good enough. If you don't understand the judge, then you are to be blamed. We are telling you repeatedly, if you stand up looking at us, we will say that they have stood up without mentioning a word, and we will proceed. You know that you have not filed counter.
Yes.
You should, first sentence, it should have been long back over. We are giving sermons to you, troubling our vocal cords for nothing.
No.
And you don't approve. No, now what we have done earlier, we have modified our orders, but we will now not modify. That they stand up, say nothing, and the order will follow. He is happy if you don't file counter. Delete.
I sincerely think.
Young man, understand. It's study. Let this weekend be an occasion to learn something more about that mere change of members does not. By mere change of members, authority does not cease to exist. It is constituted under an enactment, rules, and that rules are required to repeal the. You cannot make a statement. Supposing if we record this and send it to the authority that your council is making such submissions, what they will feel.
So sorry,
That he is so learned that he is saying that authority itself was dissolved. What is this? Learned Council for Respondents. May Huh? No. Objection to type.
In this,
we'll grant this 4 weeks. Why?
my lord, in this both the matters.
135.
Yes, 135 and 136.
Yes.
My name is not being printed, even though the Honorable Court time and again directing the registry to print my name. Due to which I am unable to follow the.
Yeah.
Yes, I have given my name.
I will see just now. Which order, Mr. What's your name? You are appearing for petitioner?
Petitioners.
Huh? What's your name?
I have given the slip. Mirza Nisar Ahmed Beg. I have given slip.
Office is directed to reflect the name of Mr. So and so as LRs. Proposed LRs of which petitioner? Which appellant? Several or one? So office that reflect Mr. name of so and so as counsel for appellant, LRs of diseased appellant.
Appellants.
No, counsel for appellants. Appellant. Then Mr. You, madam, you also appear. Both of you appear. What's right? Your name, please give. So and so learned counsel appearing for proposed LRs of diseased appellant. Praise foreign is granted for Six also same order, 36.
8 with lordships. I filed this contempt case basing upon the orders of this honorable court dated 2/1/2023, my lord. R1 and R2 filed SLP before the honorable Supreme Court, my lord. They have obtained stay, my lord. These are the copy, my lord. In this matter, my lord, please, I may be permitted one submission, my lord. As per this honorable court has not passed.
1 minute. You know the order passed on 28 July.
2/1/2023, my lord.
No, you
I have filed this contempt case.
No, you are Mr. Srinivas Sharma.
Yes, my lord.
We need to tell you what order has been passed on 28 July 23 in your presence.
No, because our certified copy order has to be filed with application SR number 68.
Correct, 2/1/23.
Yes, my lord.
You have not
This honorable court has not passed a separate order in the stay application. That was passed in the bind case itself. I have filed page number 16 to 19. Once again, obeying the orders of this honorable, I filed along with the memo, my lord.
This is contempt. It means you in spite of this. So defeat first.
Another submission, obliging the orders of this honorable court, I have filed certified copy also, my lord. In this matter, the R1 R2 filed is SLP before the honorable Supreme Court. Honorable Supreme Court has granted further proceedings remain stayed. I have filed in material papers. I also just circulated the copies.
On the question of admission, this petition has been filed for non-compliance of the order. Order.
I also filed another certified copy, my lord. Problem.
Notice of this petition has been issued. What? Mr. Sharma, it is issued. Yes, yes.
Lords, in this complete office objections, my lord, but office wants direction from this court to number it, that's what the registrar has informed us.
Office objections, you sought time.
I complained, my lords.
Complied?
I complained.
What have you done?
Because last time Lordship did not say after compliance, number it, they are again.
Amended cost title in civil suit 13 of 1958. Where is amended cost title?
That is not available in the court registry, my lords.
How can?
It's not available in that. Not this.
How can this be?
I gave letter to registrar also, my lords.
You said that I asked.
Just now you said you have complied the objections.
Yes, that, what objection there?
How can you say that? You should say that I am not in a position to comply because copy is not available.
sorry.
You are saying that I have complied. Mister, you are an officer of the court. When you make a statement before this court, we believe it. Don't mislead.
No, my lord, sorry.
Don't. What should you have said? That, sir, this I am unable to comply with first objection because cost title is not available in the registry.
I gave letter to registry also, my lord, to furnish.
Then why did you say that I have complied?
Other objections, I complied, only this objection, I don't know what they have written that. Other objections, all I complied with. Last time, what objection they were given, I complied with.
Did you effect service on all the parties?
Lord,
that was the second objection, right? Service to the
that
effect.
I paid BATA, my lords. I served copies on the commissioner receivers. I paid BATA to all the respondents, my lords.
Where is the copy? Where is?
But that,
filed it.
that objection not taken now. I filed, my lords. BATA I paid to all the respondents. It will be written in words in that.
Where is proof of service to respondents?
My lord,
how Mr. you are saying that?
BATA I paid, my lords, to all the respondents.
What is paid?
My lord, postal charges, my lord, I paid. Process fee, my lord, I paid.
Process fee.
I paid, my lord, to all the respondents.
No. The moment you pay, the presumption arises that they have been served. You are not required to file this thing, a proof of service, right?
But unless court orders notice, my lords, I cannot take notices to them because they're
Are you not, under the rules of this court, are you not required to serve an advance copy? That's how these people appear. Most of the cases I've been noticing that even private respondents appear. We ask them how you are appearing. We have yet to admit the intra-court appeal. He says on advance notice. That means there has to be a rule in place which permits you, which requires you to serve an advance copy.
But parties are representing the advocate commissioner, receiver, but they are representing the parties, my lords.
No, Mr. Thing is simple. If you don't want to comply, fine. The consequences will ensue. Your destination is northwards. Proceed.
Because we file BATA.
If you don't want to comply, say so. I don't want to comply. We will pass an order.
Amended caution, my lords, I gave letter to register. Lords may kindly have a look at it, my lords.
Mr. We had last time, please understand, on 28/7 we had granted you, you had prayed for 2 weeks time to comply.
Yes, lords.
Now you are under an obligation to tell us that I have complied. First instance, this all being noticed, right? We remember, right? First instance you said I have complied with. That on verification of record, that statement is found to be incorrect. Now your second submission is that cost title of civil suit is not available in the record. Again, if that is found, you again will be guilty of making a second incorrect submission before a division bench. Third is you are not prepared to file proof of service. And you are arguing on office objection. What, Mr.
Milord, individual persons, Milord, court orders notice, Milord, will take notice, Milords. But BATA, Milord, I paid. We usually pay BATA to all the respondents, Milord. That
doesn't mean it is understandable that you pray for time to file proof of service. That we can grant further time. But don't say that moment I pay BATA or whatever, they are deemed to have been served. In some other case, where Mr. Senior Counsel will appear, the moment he will pay charges, we will take, next day we will take, you are served and pass an order against you. If you are a respondent in that petition, right? What is this?
May I just say this, Bullet? As far as the writ proceeding rules of this court,
yes.
I am not in this case.
Yes.
As far as the writ proceeding rules 1977 of this court are concerned,
yes,
the service in the writ petition is deemed to be service in the writ appeal, that is intra-court appeal also.
Oh.
That is the reason why in the intra-court appeal, Malad, even without filing caveat and Vakalatnama, the successful party before the learned single judge take notice and oppose. They appear. But as far as
they
civil
are,
matters,
no, no,
as far as
so
civil matters
the
are
one minute, for our understanding, if they appear, it's not that necessarily they have the copy of memo of appeal. They are not supplied.
the intra-court appeal will not be registered unless copy of it is served on the successful party.
So then,
that is the rule.
Yes.
Therefore, it is a service, and after service, the registry numbers the appeal and places before the honorable court.
So that's what the objection here is, that you should file proof of service.
This is the civil proceeding, my lord. Writ proceeding rules do not apply. As far as civil proceedings are concerned, the appellate side rules are different. Their service, my lord, is
So you are
service.
trying to tell us that this registry is placing this objection by relying on writ proceeding rules which do not apply to this, as it is a civil proceeding, correct?
This is a civil proceeding, is it not? No, as far as CS matters are concerned, my lord,
So those rules do not apply.
they will not apply. The rules
That's what
will
we
not
are
apply.
saying, Mr.
Civil procedure code provisions will apply. That is, service is to be effected.
No, but what happens to his objection, Mr.? Now you have taken up his cause, so we will put a query to
No,
you.
I in fact wanted, I was anxious to tell this to my lords, because his civil suits are 1958.
58.
And the addresses of the parties as given in the plaint are not existent today.
No, the office, correct. Office objection in his case is amended cost title in civil suit number so and so for the purposes of verification of cost title since not tallying.
Amended cost title, my lord, is not maintained in CS matters. These 4 suits are unique, separate, not like other civil suits. The registry, these were suits filed in the district court. They were withdrawn by the High Court for lack of volume of work in 1958. Now, my lord, there is no original filing insofar as this court is concerned, as far as civil suits are concerned. These are the transferred suits from the district courts.
No, in that very civil suit, he has filed an application under Order 22, Rule 10. So, whatever his cost title must tally with the proceeding from which it arises. So, he doesn't know which proceeding is seeking impleadment, that means. He doesn't know that which OS, if he doesn't know the names of parties, that means we proposed that he doesn't know which proceeding is filing under Order 22, Rule 10. What is the basis of his
devolution of interest?
That name parties are made as parties, my lords, but they say because cost title has been subsequently changed, I need to make the new parties as parties. I gave a letter to register lords, my court. I gave letter to registrar Miller to furnish me the
Sir, your cost title must conform to the amended cost title. Thereafter, just a minute, listen. There is a procedure for everything. Thereafter, you file an application to this court seeking amendment of cost title and saying whatever reasons you are already telling us, and we permit, that's a different case. But it must conform initially to whatever has been mentioned in the cost title of OS 13 of 1958. Thereafter, you may file an application seeking leave to amend for stating X, Y, Z reasons, saying that this is not tallying, address, as senior counsel said, address has changed, whatever. But you cannot, at your will, describe anything as per your convenience, and you tell us not to this thing insist upon it. You are saying that unable to, he is stating not willing to comply, dismissed.
I gave letter.
Whatever he has to vary, with the leave of the court. It's undo on his own.
Well, I gave a letter to registrar. May I kindly peruse the letter once, my lords. I gave letter to registrar to furnish me, my lord, to which order copy they have compared it with.
I will, then we will, shall we pass an order?
Sorry.
I like it, so not understanding beyond too much.
I'll comply, my lord.
We are not sitting here to convince you, mister. Please understand, it's your own. We have not moved any order 22 Rule 10. And if you are not, we are not, our job is not to convince you till you get convinced.
No,
sorry.
Sorry,
this is High Court, and we will dismiss your application.
I'll comply, my lords. I'll comply.
The moment we say dismiss, you understand, right? Immediately. And we have been good to you, saying please do it, unable to understand. Perhaps we should, every case we should say, if you don't listen, it is dismissed. Any counsel will immediately, oh, no, sir. Yes, sir, please, what do you want to say? I am ready to listen.
I type one.
Shall we pass an order?
I'll
It's
comply.
of course open to this thing. You have a right of appeal against our order. Please go ahead.
I'll comply. I'll make appropriate application. I'll comply.
For this,
I'm
very
not
pur-
able to comply.
you have wasted how many times you owe all these people who are sitting and watching your performance. We thought that live streaming will improve your performance. Nothing has happened. We are under stress because we have to speak louder and all that, and we are being watched. But we thought that it will improve the performance of judges as well as lawyers. But that side, nothing. See, for this purpose, 28/7, 2 weeks time, despite 5 minutes of sermon and exchange,
I'll comply. I'll make my effort comply.
why you should not have said in the beginning?
Because
Learned counsel for the same order, right? Simple, right? We told you the way out also. He is sitting, he will guide you. We are sure senior counsel will guide you
I'll take.
what to do. 140. You, for whom? 1 2. Learned counsel for
I'm
respondent
appearing for respondent number 8.
1 to 6 and respondent number 8.
Not served on. I haven't received the copies.
1 to 6 for and are granted. How much time? 4 to 3 weeks time. 3 weeks time to enable him to file counter. Nobody is appearing for petitioner, so we cannot issue any direction. You should understand. So mark his presence. You don't want to file counter. When the copy will be when he will appear, and when he then we will ask you to supply you a copy. Then you file counter.
I'll obtain a copy.
Better no.
I'll obtain copy.
1 to 6 and 8. Pray for and granted. 3 weeks time. You say none for the petitioner. Again today also right. Then perhaps we can do it. This has to be dismissed. What do we say? Then had appeared on behalf of the applicants on 4/8/2023. Thereupon, this court had passed the following order. Paragraph. None has appeared even today. It appears that the applicants are not prosecuting in interested in prosecuting what? Not interested in prosecuting the application. The same is not interested in prosecuting the application. Accordingly, same is dismissed for want of. Yes. 142. Yes, Mr.
SSR Murthy requested 1 week meeting. Personal engagement.
Same 4/8/23 he was all unwell. We believe that he is well today.
1 week meeting.
So let's see. What ground today you want an adjournment? What's your name?
Krishna Reddy Millard.
So we remember you next date. Then you will appear again. You have been engaged to seek an adjournment, right? All the time. Huh? Last time also 4th August you appeared before us and sought for an adjournment. Why do you want an adjournment? At least you have to tell us.
It's personal inconvenience, my lord. Difficulty I'm not.
Mr. So and so. What's your name?
Krishna Reddy Millard.
Learned counsel. Once again, prays for an adjournment on the ground that arguing counsel, Mr. So and so, is not available on account of personal inconvenience, on account of Uh, by way of indulgence, hearing is deferred, list after 2 weeks. One 43.
Maybe this application, Lord, I'm permitted.
Same order.
Lord, I'm permitted to withdraw with liberty to, Lord, to pursue, Lord, as and when the application filed by the respondent.
Liberty.
Humble submission, my lordship. I am
Liberty to do what?
to, Lord, this application is filed, my lord, seeking direction to the respondents, not to entertain any application filed by the unofficial respondents.
So, with the liberty to pursue such remedy as may be available to you in law, correct?
Yes.
Learned counsel.
My lordship.
You are opposing the prayer.
No, my lordship. I'm respondent number 1 in this. I just wanted to inform this honorable court. I have filed an objections before this honorable court, my lordship. Kindly peruse.
No.
Yeah.
Mr. You have heard him saying.
My lordship.
So then you want to oppose the prayer?
No, my lordship. But the fact is, I want a clarification from this court.
No clarification. Seek. If you want clarification, file an application.
I do it.
In an application filed by the applicant, which he wants to withdraw, you cannot seek clarification.
I have been aggrieved by this application. Just 1 minute. If it's 1 minute, my lordship.
Please
Lord,
to
then-
understand, he wants to withdraw the application.
Yes.
Before you agree with that,
We asked you.
granted, if you're still aggrieved, you can pass it.
You file an application seeking clarification,
Much of my lordship.
right? You have not filed any application seeking clarification.
Much of it.
Mark the presence, learned counsel for the applicant seeks leave of this court to withdraw the application with the liberty to take recourse to such remedy as may be available to him in.
Lord, on 144 senior counsel is Lord, short pass over.
What passover, mister? No passover.
Or next week, Lord. No, my lordship. They have been taking time from last 4 times, my lordship. From four
So what, I mean, we should decide it right now and award you the order, supply at your residence, right?
My lordship, we have been.
You you are an outstation counsel here or based here only?
Yes,
what are you?
I'm just, no, my lordship. I'm here.
Here only?
Yeah, here only, my lordship.
You know this your colleague?
Yes,
You know your colleague?
we know very well. I know him from 20 years.
Ah, and you know the counsel who is this thing making, on whose behalf?
Yes, my lordship. Last week also they have taken time, my lordship. That is the
We
reason.
don't understand, but last order sheet at least doesn't indicate so. It records Mr. J. Prabhakar, learned senior counsel, list on 11/8.
Yes, my lordship.
So the order sheet doesn't record that it is adjourned, and I think perhaps
Okay, my
all of us have been at the mark.
Yes, my lordship.
And in case of a genuine thing,
Yes, my lordship. Much of it.
not necessary that everything, whatever comes from the other side and from us, have to be opposed as if we are sworn enemies. Nothing of that sort.
Yes, my lord.
We are trying to find a solution to a legal problem within 4 corners of law.
Yes, ma'am.
Your colleague,
Yes, my lord.
you can understand that next date it be taken up or something like that.
Yes, my lordship. I'm ready for that. Much obliged.
Mr. Ask senior counsel to be there.
Yes.
What's your name?
Yes,
Learned.
I'm Krishna.
Again, praise for adjournment on the ground that
Lord, this application is a passing of a final degree, my lord. 124 cents in survey number Ashmatpet village.
What is the status of OSA 44 of 2002?
Receiver report, ma'am. This court is directed to the appointed new receiver from commissioner to direct the submit the report, ma'am. After filing of the report, the finality may be drawn up. You are awaiting for the report of the receiver, my lord, new receiver. OSA 40.
Awaiting report of the commissioner. Hearing is deferred, list after 4 weeks. The same. Which order? H2. Put it like ulta. Yes. None for the petitioner. Awaiting the report of the commissioner. Hearing is deferred. List after 4 weeks. Yes.
Yes, but I'm appearing for respondent.
See the application filed under 21 rule 97 that to remove the obstructions by the respondent.
Report of the commissioner awaited or filed.
We have not read it, sir.
Filed.
14 matters, madam. See, report of the commissioner is awaited, madam.
Awaited. Will that defer? Awaiting report by the commissioner.
In fact, report was already filed in respect of this property. Final decrees are passed. It is under order 21. Blood. Only one property is blood left over without filing report.
So new commissioners have been appointed.
Yes,
You
yes,
don't know.
Yes.
Huh? Then why
Let
should
them-
you say that?
Let them file.
Same order awaited. 4 weeks. Same order. Yes. 4 weeks.
That's 149 up to blood 151 are connected to 147.
149,
149
connected matters.
150, 151 are connected to 147.
Whatever order has been passed, what order report 147, what order have you passed?
Blood, await report 4 weeks.
Same order in 149, 150, 151.
Awaiting for the report.
Same order. Await commissioner's report list after 4 weeks.
Same minutes, awaiting report.
Same order 153.
Privileged.
Report of the commissioner is awaited, madam. Report of the commissioner
In
is
this
3 matters.
I appear for the respondent, writ petitioner, Advocate General's appeal, Mallet. State has filed this writ appeal. Mallet, the background is this, Mallet. I am a purchaser of a parcel of land from a person who has got it under
No, but
CS.
this is come on suspension, implead, IA. It has come up on orders on IA under interlocutory.
I'm up
Two applications for impleading and suspension are pending.
No, impleading application, Mallet, is being opposed. Suspension is the suspension of the learned single judge judgment itself.
So what
There has been a suspension, Mallet, on the day when it is admitted in 2016.
Right, so we can dispose of this IA 1 of 16, or you want to argue?
No, I would like to argue, Mallet. I just tell to kindly give me only 2 minutes, Mallet.
Yes, sir, please.
My vendors have got this particular parcel of 24 acres of land in CS number 14. That is my sin not today. And I purchased them, changed under a registered sale deed, and thereafter applied for mutation under the.
They have got it, your vendors got it.
My
under-
vendors got it in CS number 14 of 1958.
How?
And because of a final decree passed there. Well, that is not the issue in the present case.
No, you said that they got it in CS 14 or 58.
Yes.
We are just asking how they have got it in CS 14.
In a final decree proceeding passed in CS 14. Then I have purchased from them. The short point is this, Palit. After purchasing under registered sale deed, I applied for mutation under the record of rights.
Registered sale deed dated. Registered sale deed.
Sale deed dated 10/6/2005. 10th of June 2005.
Yes.
Then on the basis of this sale deed, I have applied for mutation under the AP Record of Rights in Land and Patadar Passbook Act 1971, for short the ROR Act. The state authorities have granted mutation in my favor. And that mutation is subsisting. And after the mutation, on the basis of mutation, I have requested the state authorities to disclose my name in the Pahani Patrika. I gave a legal notice before approaching this court. The state is disclosing this particular survey number 77 of Hafizpet village as government land. Under this act, 1971 act, the act does not apply under section 12 to government lands at all. And then learned single judge allowed my writ petition. Learned single.
In which district is that?
Hafizpet comes in Rangareddy.
Which you said Hafizpet village is something you said.
Hafizpet village is the village in which this land is.
Where is that village? Which district?
That is in Rangareddy district.
Okay.
Seri Lingampalli Mandal, Rangareddy district.
Okay.
And after the mutation has been granted to me, which is subsisting, since my name is not reflected in the Ani Patrikas, which are revenue records under the same act, I have approached this honorable court. So long as the mutation is subsisting, the non-disclosure of the name of the writ petitioner in the Pahani Patrikas is arbitrary. Learned single judge accepted the contention and allowed the writ petition. Then against that, state authorities have preferred this writ appeal. These implead party petitioners are coming now for the first time in the writ appeal, saying that they have also got a claim over this particular parcel of land. They do not have any document or any final decree. That is not the subject matter of the present writ appeal. It is the state's appeal. How learned single judge has
got it. Yes.
I'm appearing for the petitioner on behalf.
No, if you want anything, madam, file a petition. If you are owner, do whatever you want to. In this writ appeal filed by the state, we are not going to declare that you have title in respect of land and all this. Application under Order 1 Rule 10 for impleadment can be filed. It can't be filed to enhance the scope. It doesn't provide a remedy, nothing. There is an order subsisting in his favor, the state is aggrieved by it. We will decide what is to be done, but your claim can't be entertained, correct? We are sure about it.
You let me permit to speak on this. Your Lordship, in the
Of course, but don't feel that we are not permitting. Take the mic. But we thought that anybody will understand what is the scope of Order 1 Rule 10. You must have read. No, not read.
No. Lordship, in the petition itself, we have filed an implead petition that was not considered by the lower court.
Learned single judge rejected it.
Madam, this is not lower court and all that. That shows your inexperience. When have you joined, madam?
Your Lordship,
When have you joined?
I am a very recent joining. Your Lordship.
That's why lower court saying single judge of this court in a division bench before division bench is lower court.
I'm sorry, Your Lordship. Actually,
You should be, madam.
Your Lordship,
We cannot permit the dignity of this court to be brought down in the manner for your inexperience, and we will impose cost on you for addressing learned single judge as lower court.
my apologies, Your Lordship. Actually, I wanted to submit that this matter has been represented by the senior counsel.
Nothing, no senior counsel.
Lordship, due to personal inconvenience, senior counsel cannot attend to this matter. I wanted to start with that, Your Lordship. I was seeking an adjournment in this matter, Your Lordship.
You can appreciate her predicament, right? Mr. Senior Counsel, we have this, we are clear about what you have argued. We will record this. And don't come, madam, to this court, right? If you come only when you want to argue the matter, don't let like a postman thing, postwoman thing, he is unwell. There's no need. It's our case. We have taken note to do justice. We will do it in accordance with law. This, you have assured us, no, each one of us, that bar will extend full cooperation. This is the cooperation. That every time when it is called, you stand up with this. Nothing in this case. You better think about it, Mr. Except the subject matter of civil suit 14, you better think about it. How do you assail? Merits. We will hear you on merits. You are saved by her. Otherwise, we would have asked.
May I submit the copies of the order filed by the Honorable Court, my lords?
Huh?
Yes. As on today, my lord, there is no final decree, my lords. For trying a final decree.
No, argue on merits. We understand your standard argument, subject matter of civil suit 14 of 1958. This is what we know, Mr. by now. Each one of you have started knowing. What will you argue? We can anticipate.
My lords, sir, please to appoint.
That's why we are saying, argue on merits of the matter. How do you assail the order passed by the learned single judge? Have you cancelled this patta granted to him?
My lords.
Right? And if he is what passbook is standing, how can you, and whether entry in the revenue records confers any title
It doesn't.
on any person, right?
My lords, Honorable Supreme Court, my lord, recently while adjudicating the Hyder Nagar issue, my lords.
No, Mr. We are putting you on notice. You say I will examine. Don't argue right away.
Yes.
You know that she is seeking adjournment, and we can decide her application right away, but she will be in trouble.
Yes.
Her senior will say that you are not good enough even to seek an adjournment. What will happen? She is just joined the profession back. That's why we are adjourning.
Yes.
Her predicament, right? Mark the presence. Learned senior.
Same matter.
Same
Connected
matter.
matter.
All right.
Actually, part
There also you are seeking adjournment, madam. Next Friday, Saturday, 19th August. Next date, come prepared if your senior is not there. Huh? You read, let it be an occasion to know, you should enrich yourself. What is the scope of Order 1, Rule 10? Who is a necessary and proper party? What happens when you have an independent cause of action, right? Yes.
Well, I beg to appear in this matter. Is a application for passing a final decree in respect of one item in survey number 1 and 57 of Hashpatpet village
So
on the basis of a compromise. Well, again, this perhaps requires the report of the receiver.
That's what.
Yes, to facilitate the matter.
Await report of the commissioner list after 4 weeks.
May I just make one request for it?
Yes.
Since all cases the report of the receiver is necessary, your lordship may kindly direct the receiver to give report on each of these applications within some specified time of 4 weeks or so that they can be completed.
Commissioner reports are written. Yes, 14 and 15.
The new. Yes. 7 and 9 we have the reports, brother informs, and probably
7 and 9 reports
have been filed.
Reports are filed, but they are not on final degree applications. They are about the availability of items for partition.
So in items CS 7 and 9, reports are filed, we granted time for objections. Once the time lapses, then we will take further.
In CS 14, my request is, in CS 14, in each of the final degree application, a separate report perhaps would facilitate the Honorable Court to deal with the applications. Because there cannot be a omnibus report in respect of all the items of properties which are forming part of CS 14. For instance, the present item which is called at item number 156 is one parcel.
We can segregate your property in that he will mention of property wise only commissioners, not like.
He has been submitting reports with respect of the CS civil suit itself.
Let a comprehensive report be filed. We'll see what if it's not practicable to, then we will see what further direction on the report. Await report 4 weeks. Advocate General.
I am appealing for the appellant's This is the government's appeal. One short point for consideration that would fall for consideration by your lordship is that
What is
scheduled
this
property.
contempt appeal?
Contempt and
City Civil Court appeal. Yes, we thought, what contempt have you committed? Today only we came across a contempt appeal in the morning as first case. That's why we asked you. City Civil Court appeal.
Yes.
Brother informs.
One short point that calls for consideration is that the suit scheduled property or the appeal scheduled property.
Mr. What is IA 1 of 22? What is it? Fix a date for hearing not required.
Not required.
Who appears for respondents?
My friend said.
Senior is appearing for respondent number 1.
You are senior. You are senior appearing for respondent number 1. You are the senior counsel appearing for respondent number 1.
My senior is appearing for
Where is he? When he is, then say so, madam. Not by invitation. He is arguing short point. You should have at least been in alert mode to say, I want adjournment. Correct? Or you intended to say after he had finished the arguments? When do you want, madam?
I'm ready.
What's your name? Learned counsel prays for adjournment on the ground that the arguing counsel is unwell, not well. Huh? She therefore prays for adjournment list after 2 weeks. All cases, right?
Yes.
That's it.
Around again.
Wait, please, my lord.
Yes.
My lord,
Notice has been issued.
my lord, it's a arbitration. It's an arbitration application, my lord, wherein respondent but 1 to 3 are group of companies.
No, no,
which
this
are
is
into-
for appointment of an arbitrator.
Yes.
So say so 11/6, right? Notice has been issued, not issued.
Not issued.
There is an arbitration agreement.
Yes, my lord. Page
You
number.
have invoked the arbitration clause.
Yes.
Other side has not acted.
No.
Heard on the question of admission notice.
This is also coming for first time, you know.
First, notice, marked presence, learned senior counsel.
May be permitted to take out personal notice.
Huh?
Personal notice.
In addition, personal notice, service certificate, whatever we write. Done. In that case also, previous one.
First time allowed appointment of arbitrator.
Arbitration clause is there, no?
Yes,
okay, notice.
I said, my lord, coming for the first time, my lord, arbitration clause is there, my lord. Permit personal notice.
You have invoked the arbitration clause, right? Other side has not responded.
Not responded.
Notice.
165.
Personal service. Huh?
165, 166. Both.
Both notice. Notice. Personal notice. Proof of service.
I'm appearing on behalf of Mr. Damodar Mudra, my lord. He has a personal inconvenience. Your lordship may have it next Friday.
What do you say?
My lord.
No, you are contesting.
Yes, my lord.
No arbitration clause.
My lord, claim is barred by limitation, my lord. Admittedly, claim is barred by limitation.
Your lordship may take it up for hearing next.
The previous application was withdrawn, my lord, because they issued a notice, my lord, to a wrong address. Again, my lord, this petition was filed. The agreement of the year 2011. The legal notice was issued, my lord, during 2017. And the claim in the legal notice was for the period 2015 to 16.
What's your name, Matt?
Sagarika.
Learned counsel. Close for adjournment on the ground that the arguing counsel, Mr. So and so, learned senior counsel is not available on account of personal difficulty. List. Next week.
Friday.
Next Friday.
Friday week, my lord, next week.
That Friday happens to be Saturday, in fact.
Yes.
So, 19th August.
Very well.
Probably we will have more time.
I'm sorry, my lord. Friday, next Friday, my lord, there is a matter before the Aptel, my lord. I'm sorry.
19th August, Mr. Saturday.
But on Friday, I'm at Delhi, my lord. There is some inconvenience.
No, you can appear through video conferencing.
I'm sorry, my lord.
Because they have this thing, very good facility in Bar Association. One counsel who had gone to bank.
Friday week, my lord.
No. We are telling you, one counsel who had gone from Bangalore had gone to Delhi. It was an urgent matter pertaining to medical admission. So he addressed the division bench, including me from Delhi, and said that I am indebted to them for excellent video conferencing facility. So in case you are going to Supreme Court, that facility is available.
Not, my lord, that much serious matter.
Whatever, yes, madam.
Friday week, my lord.
Very well.
Friday week means
Next Friday.
After 2 weeks, my lord.
25th happens to be holiday. Let's see, if 11/6 stage we are spending so much of time, what happens when the arbitration begins?
We'll proceed with our arguments on the next date of hearing, that is next Saturday. And he can continue on the hearing.
Not piecemeal, madam. What? There is no point. Give me an agreed date.
My lord, any date, my lord, after next. 24th. After first week.
Your lordship may have it on 1st of September.
1st September.
Obliged.
Much obliged.
Manoj, item number 169 may I be permitted to appear virtually, Manoj? I've
Yes. 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 Oh.
My lords, in this matter, counter is filed, my lords. This is Section 11 application. They have not denied the
saying-
existence of arbitration clause. They have only
One
contested the
minute.
merits of the case.
Why? Mr. At 11.6 stage, you are, keeping it pending like a civil suit. What is there? Where is an arbitration clause? You should, give us an agreed name of honorable judges, whosoever you want an arbitrator.
But we had proposed a name of a former High Court judge, my lords.
Who?
Whether his lordship or any other former judge is amicable.
Huh?
The dispute is
There's
around
nothing more handicap.
1.73 crores, my lords. Maybe a former district judge may be appointed, my lords, subject.
Former district judge.
Because the quantum amount is only 1.73 crores.
Huh? Don't leave it to give us an agreed name, so we will appoint.
We had proposed Justice Bhavani Prasad, my lords, former judge of this honorable High Court.
No, as Harif means. Huh? Yes. I don't know what is Justice Bhavani Prasad.
Yes, ma'am.
He is a former judge of this court.
This honorable High Court, ma'am.
You don't have any objection. Fine. Then why are you seeking adjournment handicap? No handicap. Yes. Huh? Nothing, Mr. Hey, what, Mr. Ari, you said you have no objection to appointment of Justice Bhavani Prasad, and you are now saying that it is null and void on all grounds, including jurisdiction under Section 16. Everything. Huh? Mark their presence. Mark everybody's presence. Petition is admitted for hearing. In this petition under Section 11 within bracket 6 of the Arbitration and Conciliation Act 1996, the petitioner inter alia seeks an appointment of an arbitrator to adjudicate the dispute between the parties. Full stop. Bangalore, where the arbitrators go and conduct the proceedings.
Yes, ma'am.
I am asking whether, or you will hold in one hotel another day, next hotel in another day, like that.
But these days, some former arbitrators are conducting proceedings at the residence only, ma'am. That is more convenient for all parties.
So what is it, madam? Huh. Oh. The parties undertake to appear before the sole arbitrator along
2 weeks from today.
yes, one after 2 weeks a date, Mr. 28th August.
Oblige, my lords.
On 28th August 2023, along with a copy of this order, the learned arbitrator shall thereupon enter the reference and proceed the no, what is not an arbitration clause?
There is an arbitration clause, but the claim is of the year 2011 to 12. The arbitration clause is in page number 31, my lords. Claim is of the year 2011 to 12. Page number 30.
Barred by limitation.
Barred by limitation is my contention, my lords.
So therefore, what is the case law on which you are placing reliance?
My lords, I shall place case laws. Next step.
None for the petitioner, Mr. So and so learned counsel for respondent. Awaiting appearance of learned counsel hearing is deferred. List on 19/8. We will Saturday, no, Mr. 19/8/23.
Oblige.
Lordship, in this matter, petitioner counsel seeks 1 week time, your lordship, due to personal inconvenience.
Okay, what 2022?
Your lordship.
What, Mr.
1 week time.
Name.
Ravi Teja, your lordship.
Learned counsel prays for adjournment on the ground that the arguing counsel, Mr.
Prabhakar Sripada.
He is not available. List on 19/8. Please argue. Arey, you don't see the cause list, right?
171.
170? 171. SR notice returned unserved. They have been served, not served. You will have to take steps. What does it, Mister? You're looking at him, you find out served or not. We have to tell them, right? You don't know anything. The responsibility of the court, right? To find out. Huh? Huh? Then it's served or not, Mister. This cause list says SR notice returned unserved. Then mark his presence, Madam, right? Office report indicates that respondent has not been served. In view of aforesaid office note, learned counsel for the petitioner, place for him is granted a week's time to enable him to take steps for service of notice on respondent
Very much.
on correct and complete address, right? You say take steps for service of notice. That's all. Don't say, Madam, don't say correct and complete address. Say only take steps for service. Next. 172.
Appearing for the applicant in this matter, my lord, there has been appearing for the applicant in this matter, my lord.
Why don't you come here? It gives an impression you are government advocate. Yes. Yes, Mister. What do you want? Tell us.
There has been no representation on behalf of the respondents on multiple occasions. Neither has any counter been filed in this matter.
All right, so fine. Go ahead.
Lordship, agreement is at page number 45.
What date?
Agreement is dated 24th November 2020.
24th November. Mister, they have been served. Huh? But
Wakalat
Mr.
has also been
one thing. Huh?
Wakalat has also been filed on behalf
Why?
of the respondents.
You are
However, no one has been
represented by a council.
Sorry.
Represented by a council.
Yes.
It's coming under caption admission. So technically speaking, if they don't turn up, perhaps we have to admit. We'll list it on 19.8.
Much obliged.
Our petition is admitted for hearing, list on 19.8 for final hearing. In case it doesn't turn up, we decide.
Much obliged.
So the technical objection shouldn't be there, right?
Yes, ma'am.
Otherwise, a recall that at the most court would have admitted, not decided. Give us this thing. Brief synopsis, right? Clause and all that. So,
By the next date of hearing, it will be ready.
or give it so that we don't waste like even a
As of now,
30 seconds we decide it.
I'll prepare by the next date.
Next week, 19th August.
Very well.
None for the petitioner awaiting appearance, hearing deferred. List next week, 19.8.
Petitioners, on last time they have sought time for filing a counter, but they have not filed any counter until now.
So and so none of it, no, there. Didn't file. Paucity of time I sat last date at 4:35, so nobody was there
Even before that, my lords, they have sought time for counter.
before.
For respondent, right?
You want to file counter, right?
No, my lord, we collect the papers right now,
How much time is?
like by next week.
Raise for adjournment to enable him to file counter.
Direct the petitioners to
List
serve the
on
papers.
19.8. Supply him an extra set if you want decision, right?
Yes, my lord.
19.8. You give him today extra copy. Instead of getting into the dispute.
Yes. Obligations.
Appear for the sole respondent, your lordship.
Appearing for the
Request- Appear for the respondent, your lordship, requesting 2 weeks time to file counter, your lordship.
Your lordship, I kindly record as a last opportunity, your lordship. Hence, they've been asking since 5-6 times. Your lordship.
Madam, 10th of February 23, 4 weeks. Thereafter, how many 4 weeks have expired?
First time, your lordship, after first.
No. 10th February 23, 4 weeks. 10th March expired. We are in August.
Finally, 2
5
weeks.
months.
Finally, 2 weeks, your lordship.
Therefore, she is right.
Because we had.
Despite opportunity being granted on 10/2/2023, the respondent has not filed a counter. However, by way of indulgence, 2 weeks further time is granted to the respondent to file counter, failing which appropriate order shall be passed.
Deeply.
After 2 weeks, what date?
19.8.
28th is the Friday. Then 1st September by 20.
Obliged, your lordship. Deeply obliged.
Deeply.
My lordship, appearing for the respondent, requesting 2 weeks time, my lordship, counter is filed. Senior is, due to personal inconvenience, senior is out of station, my lordship. And
So you have to file counter.
filed, my lordship, already filed. Already filed.
All right. Learned Mr. So and so, learned counsel for respondent place for adjournment on the ground that the matter is has to be argued by so and so who is not available on account of personal difficulty. 19th August he would be available, right? 19th August 23.
Obliged.
My lord, I am for the petitioner, my lord, in this matter.
Yes, yes.
So, my lord, in the connecting matter, my lord, Justice NRL Nageswar Rao has been appointed, my lord. So, my lord, may appoint the same learned arbitrator, my lord, so that
Correct, madam.
the consolidated proceedings could
Oh.
be conducted, my lord.
No. Did you hear what did the senior counsel said, counsel appearing through video conferencing. One of the connected matters, who has been appointed?
Justice N.R.L. Nageshwar Rao, my lord.
NRL.
That's correct.
What? Former judge of Supreme Court.
No, my lord, he is a former judge of this unified High Court. My lord, I have dropped in his address and his name in the chat box.
Oh. To oppose. Instructed to oppose, instructed to seek adjournment, and if it comes to that, to oppose, but not to say whether the statement made by counsel for the petitioner is correct or not. Madam, please see the futility of exercise you are indulging. This is a fait accompli. Even if senior counsel appears, even if God appears on your behalf, nothing can be done. This is in a connected matter. This, what is arbitration? Speedier forum, or we should compete to keep it pending for like a civil suit for 20 years, so everybody dies and we are all happy in heaven. What?
My lord, if my learned friend has any objection, my lord, section 16 is there, 12 and 13 is there, my lord.
All objections, madam.
Those objections, my lord.
No, we are asking you about the correctness of a statement made by the petitioner that in a connected matter, former judge of this court, Mr. NRL Nageshwar Rao, has been appointed as an arbitrator. Is it correct or not? Then we will grant you opportunity to file counter in case he is making an incorrect submission.
Not the present matter. I've been instructed that the parties so to say the same I file the comment.
Yes, Mr. Counsel, what can be done?
This order has been passed by Justice Vijay Sen Reddy, my lord, of this honorable court. I'll place that order on record, my lord, if your lordship.
Unfortunate, I mean, what can we do? This is the cooperation which we get from the bar. She is engaged to seek it. Don't come, madam. Arbitration matters, please do not come to seek adjournment. Don't come.
My lord,
I know we don't like it. You people are defeating the object of this thing. Proceeding. Do whatever, we will pass orders on 19th. Do whatever you want to file counter. Don't want to file counter, I will pass an order, you challenge in SLP, correct? All of them have been served, Mr.
That's correct, my lord. All have been served, my lord.
None, nobody is appearing.
No, Lord, there are some performer respondents, my lord, and some are choosing not to appear, my lord.
And who is respondent number 6?
Yes, my lord.
Respondent number 6 is an individual, aged about 52 years. Huh?
That's correct, my lord.
None for Marcus presence, none for respondents number so and so, none for respondents those served except what? Your name is Pratik Reddy. I thought
no, my lord, she is not Pratik Reddy, my lord. She is
obviously
on behalf of Pratik Reddy.
We asked, we asked her name. She is saying Pratik Reddy. What to do, Mr. No, what's your name, madam? The counsels appearing before us have a name. You are enrolled as an advocate under a name, not as Pratik Reddy. What did I ask you? So, answer is counsel for record. What is the answer? Don't get it. Why, madam, at 4:30? We have been tolerating since 10:30, right? Why at least be reasonable to court when it is being adjourned? In a case where it should not be adjourned. Still, I am granting adjournment. Be reasonable to court. But don't appear. If you don't want to share the name, we are not interested in knowing your name. don't appear. We will say none for respondent number 6. Learned counsel for the none. He is not Pratik Reddy is not before us. Write her name for Mr. Pratik Reddy. Learned counsel for the petitioner submits that in a connected dispute between it contains an arbitration clause.
No, my lord. My lord, the dispute, may I explain?
We are asking, like, there must be a reference to the arbitrator under some agreement,
My lord, may I?
arbitration agreement. You are saying sealed it.
That if your lordship is putting me the documents which contains the arbitration clause.
Obviously.
The documents are not similar, my lord, but the subject property
What is the date?
May I?
Learned counsel for the petitioner submits that in a connected matter, justice and
Grateful. I'm so grateful.
May please, my lord. Seeking appointment of an arbitrator. Notice the count has also been filed, my lord. Request 1 week time, my lord.
Why 1 week?
Because already the
Because civil suit, right?
No, my lord.
It must remain pending for 20 years, then only we will decide.
Like that, my lord.
No, argue, Mr. On 19.8 you argue, but whatever adjournment you want, 19.8 I will not adjourn.
Already sole arbitrator have been appointed in this matter, my lords. And that arbitration case was adjourned to 14.8, and all the pleadings of both the counsels have been completed, my lords, and only the award has to be passed. The dispute, the proceedings before the sole arbitrator that are pending are the dispute between the landlord and the
different claim.
No, landlord and the builder. Whereas I am the purchaser from the builder. Now I have shelled down my amount to a tune of about 70.
Is he a party to the proceeding in the?
No. He is the subsequent purchaser. My lord. Between the builder and the spacious plea, on the spacious plea that there is a dispute pending before the arbitrator.
This is under a different agreement, right, Mister?
And
what is the date of agreement?
My lord.
Date of agreement.
Date of agreement is 20th. 7th March 2020.
7th March.
7th March 2020.
Which clause?
Clause 19, my lord.
19. Learned counsel for the petitioner submits that He'll give us, instead of contesting, give an agreed date, agreed name of an arbitrator.
Millards, for the appellants in this matter, Millards,
Yes, madam.
there is an arbitration clause, Millards, seeking for appointment.
Who appears?
Millards, we have sent a notice in this matter, but has been returned saying unclaimed, hence deemed service, Millards.
Oh, deemed service. Good.
Indeed, Millards.
So, petition is admitted for hearing list for final hearing on 19/8/23. Give 3 line synopsis, arbitration clause, agreement, listing clause.
Indeed, Millards. Indeed. Obliged.
Straightway we can proceed with the dictation.
Obliged.
They are not contesting your claim.
Indeed.
Sole arbitrator?
Sole arbitrator, Millards. Indeed.
So why we are adjourning, because formally an objection could be taken that it was for admission and
Millards, but anyways, it has been there since last 4 times, Millards. There was adjournment since 4 times, despite there being a notice being issued.
no. They have been served, right? Nobody is appearing.
No one.
We will take it up on 19/8
Obliged. Obliged.
for hearing.
Obliged.
It is not listed for hearing today, madam. It is under caption admission.
Indeed, Millards. Obliged.
That's why I have fixed it for hearing on 19/8.
Obliged.
Yes.
I request time, your lordship. Rakesh, I request time, your lordship.
Why?
Mr. Sanghi is out of station, your
You have filed counter?
No, the papers have not been.
Learned counsel for respondent.
Papers have not been served. Your
Praise warrant is granted a week's time to enable him to file counter list on 19/8. 19/8 asks him to argue. There is nothing to argue in these matters.
Papers were not served on.
Take it, will serve a copy, madam.
Extra set.
May please, your lordship. Well, as I appear for the respondents, item numbers 181 to 183 are connected. My lords, the respondents in these matters are entities of the Island FS group, my lords. Your lordship may be aware that there is a moratorium order passed by the NCLA.
We are not aware of anything. How do I know?
I will pass it on.
So how you are saying that I am aware?
No, my lords, lordship.
No, you don't
There have been
want.
several judgments, including at the, I'll pass.
Let them file a preliminary counter, my lordship, for the maintainability, so that
At least bring it on record, Mister. They don't take them by surprise like passing on documents.
My lords, you
entitled to.
permit me to file a counter solely on maintainability. My lords, I will.
You can place it on record and say that in view of this order is not maintainable.
Very well, my lords, I'll file mine.
Are the presence? This petition has been filed. This petition under section 11 within bracket 6 of the act has been filed seeking appointment of an arbitrator under the development this is 81, 82, 83. Huh?
I'm appearing for the applicant, my lordships.
Oh, together. So nice.
So, my lordship, this is an application under section 15, my lordship, substitution of arbitrator. Because the arbitrator already appointed by this court has recused, my lordships.
Oh, you agree? That's why appearing together. Which name? No, you want to oppose his prayer? Huh?
In all these
You want-
submissions were heard, my lordships, in the earlier application, and accordingly an arbitrator was appointed, my lordships.
Earlier order, if you had not challenged, then how can you challenge in a subsequent proceeding merely because the arbitrator recused? Recusal of an arbitrator doesn't give you another chance to re-agitate the matter which you have already accepted. Tell us in, be fair, Mr. This all name, agreed name. Which name?
Any panel arbitrator of this honorable court may be appointed, my lordships. There is
We
no
don't have-
consensus.
do we have a panel? I don't think.
High Court list will be
List
mentioned.
is there? Yes, Mr. List of arbitrators. Please see. You have written.
Earlier it is Justice Ramesh Ranganathan, my lordship.
So he has recused.
Yes, my lordship.
Then panel. What about Justice Naveen Rao?
No objection, my lordships.
Correct. Fine. We record your consent. Yes, in this petition. Alright, where is this your petition, Mister? I am brief submission, everything. This petition has been filed under section. Where is the prayer filed under section 15?
Appendix 1, my lordships.
Page
Section
number.
Page 2.
This petition under section 15 of the Arbitration and Conciliation Act 1996.
In this matter, as per the directions of this honorable court, we have taken out the personal notice to the R1 and R2, my lord.
She is appearing, right?
Represent A. Ravi Babu, your lordship.
And we don't know the R1 or R2. Mr. He is not a party here whom you are representing.
Okay, sorry, your lordship.
You are an advocate also, right? You are also an advocate. So you are representing R1, R2.
Yes, your
What do you want? Say so, madam. Don't look at his face.
Is it time to file counter, your lordship?
How much time? Tomorrow, this thing, 11:15 p.m. in the night? Say so, madam. Learn it. I have to make out because you appear anywhere. So I have to make out first who is appearing for whom. You don't say I appear for respondents 2 weeks time. Simple. He can be for respondents also. We don't know. Learn it, mark their presence, learn it, counsel for respondents, praise for is granted. 2 weeks time to enable her to file counter. Yes.
Much of.
I'm for the petitioner member.
Yes, madam. Counter file.
5 and 7,
I
have no objection for appointment of arbitration.
Good. Yes, please suggest the name.
Name,
High Court, retired High Court judge,
retired
my lord,
High
because
Court
the
judge.
amount is more than 1 crore.
Tell us which name. Have you gone through this list of former judges? You want former judges of this court, right? Please go through the list, madam. Both of you jointly. Where is this?
Lordship, you suggest any name, my lord?
No, we don't know. Please see, both of you jointly, and remaining respondents are not served.
Yes.
Yes, this petition. In the meanwhile, I will write you go through, jointly go through. This petition has been filed. This petition under section 11 within bracket 6 of the Arbitration Conciliation Act 1996 has been filed seeking appointment of admittedly the registered documents instruments executed between the parties contain an arbitration clause. Let's stop. Paragraph. See who you want.
Chandra Kumar.
Justice
Justice
B. Chandra Kumar.
B. Chandra.
V or P? B. Bombay. Justice B. Chandra Kumar, a former judge. He will accept, right? He's in the panel.
The ban.
Yes.
B. Chandra Kumar, former judge of this court, be appointed as sole arbitrator to adjudicate the dispute between the parties. In view of consensus arrived at between the parties, Mr. Justice B. Chandra Kumar is appointed as sole arbitrator to adjudicate the Accordingly, petition is disposed of. Next.
Petitioner, my lords. The agreement.
Also, I'm appearing for respondent. I have no objection for appointment.
This petitioner. So please tell us.
Justice Venkateshwar Reddy.
No.
Justice Venkat.
Justice Venkatramana. Justice M. Venkatramana is former judge of AP High Court.
He is stationed in Hyderabad.
He's stationed in Hyderabad. That's okay.
This petition under section 11 within bracket 6, same matter. Of the arbitrator seeking appointment of sole arbitrator
1/5
under the agreement dated
1/5/2013.
1/5/2013. It is not in dispute that the aforesaid arbitration agreement. Yes.
I'm for petitioner, sir, applied for sole arbitrator appointment.
And for the respondent, we are going to file counter in this matter, Lord.
How much time? 19.8?
Yes.
Learned counsel for respondent prays for short accommodation to enable her to file counter list on 19.8/23.
Right.
Who get that panel thing, Mr. Court Officer? Panel you had given, take it back.
May I please your lordship?
Kuch lekha. Counter, next case.
May I please your lordships? Appearing on behalf of respondent lordships, kindly accommodate 1 week times to file.
2 weeks last time you were granted.
They're ready, my lords. We have sent them for.
Direct counsel for respondent
Kindly,
prays for is granted a week's further time to enable him to file counter list on 19.8/23.
Obliged.
I appear for the applicants. On the last occasion, my lord,
I appear by the respondent, my lordship. We are entering appearance today itself. Copies were also served today. We will file a counter, my lordships.
How much time?
2 weeks, my lordships.
Correct.
Very well.
Learned counsel for respondent prays for is granted 2 weeks time to enable him to file counter.
1st September.
List on 1st September 23.
My lords, I am appearing for item number 192.
Correct. That's why you are standing.
My lords, my humble submission is that item number 193 is also a connected matter. First listen that because the service has been done in that matter also. But the item has been returned in this matter.
It has been returned.
Lords, the personal notice has been returned in this matter.
Unserved. In view of office note, in view of the endorsement that the notice issued to respondent has been received back with the endorsement that the same has not been served. Learned counsel for the petitioner prays for is granted a week's time to enable him to take steps for service of notice on respondent. Next. 193.
My lord, in this matter,
Served.
it has been served.
Petition is admitted for hearing list on 19/8/23.
My lord, in both the matters, both addresses are same. My lord, it has been
We can't
intentionally,
treat-
they have.
Please understand what is the law. That one case served, another case it should be treated as a.
Same address, same floor.
We understand
Everything
the
is
mischief.
same. My lord, they haven't replied to my legal notice in which I have invoke my
You
arbitration.
don't want to pay process fee?
Sorry, my lord.
You don't want to take fresh steps, we will pass an order dismissing your petition.
No, my lord.
I understand the mischief, mister, but please understand.
Not a personal notice, a court notice should be issued to them. A notice to the court should be issued to them.
No, we are not seeking appointment under section 11(6). The High Court is not seeking an appointment. Why court notice? You take steps.
My lord, I'll send it again.
19.8. 1890. Please understand, I appreciate that they are playing mischief, but I cannot hold that since in the connected matter they have been served on same this thing, therefore they are deemed to be duly served. Can we pass such an order? Then I understand what you are saying, not that, but you take steps.
But my lord, in one which
Proof of personal service, proof of service, whatever.
my lord,
Yes.
one has been served, my lord. 193 has been served.
That we have fixed it, we have admitted it, fixed it for 19.8 for hearing. You didn't hear us. Yes.
I'm for the applicants, my lords. Lord, the proof of service is filed, my lord.
Ah.
Lord, there are applications, my lord. I am seeking permission, my lord.
Acknowledgement is there?
Lord, there is.
Served.
Yes,
None
proof of
for
service.
respondent, though served, petition is admitted for hearing, list on 19.8.
One small submission, my lords. There are permissions sought, my lord. GPA petitions is filed, my lord. The petitioners sought representation through GPA holder. So that permission is sought, my lord.
GPA holder?
Yes. Petitioners are representing through a GPA holder, my lord. So that
we will consider it on the next date of hearing. So see, madam, you don't admit it. Proof of service filed, respondent duly served, list on 19.8. 19.8. It's beyond 5 o'clock, 4:30. That's why he may say that I'm not supposed to appear, right?
Your Lordship, I'm for the applicant, Your Lordship. Personal notice was attempted, Your Lordship, on 2 addresses, factory as well.
Office report indicates that service of notice, that the service of, that the notice issued to respondent has been received back unserved.
And
Learned counsel for the petitioner shall take steps for service of notice on respondent within a week.
Your Lordship, even personal notice was attempted, Your Lordship, but both the notices came back, Your Lordship, only 2 days back.
What is Madam Order 5 Rule 20 of CPC?
Your Lordship.
Ask court everything, right? The court will advise.
No,
Tell the court that I did this, the court will advise.
No, Your Lordship.
Then you will in the application write that the court had directed me to file an application, therefore I am filing. If you can't serve, then
I have served it, Your Lordship. Memo of proof I'll be filing in 2 days, Your Lordship. But just 1 week
this
time.
indicates that respondent has not been served.
The RPADs will return back.
I don't know, madam. What should you do? Please ask. Some senior counsel is there here. Nobody is. You will not find anyone at 4, 5 o'clock. So please ask somebody.
I shall.
We are not here to advise you what to do. We will go by this.
I shall make
That
an attempt.
endorsement in the cause list says that not being served.
I shall make.
Take steps for service
Oblige, Your
within a week. Yes.
Your Lordship, I'm appearing on behalf of Mr. S. Sridhar, Your Lordship,
Whatever.
requesting 2 weeks of time to file some.
That's what is important.
Yes.
Learned counsel for respondent praise for is granted 2 weeks time to enable her to file counter. Office, what the name is there. Yes. Yes. None for petitioner. Awaiting appearance, hearing deferred.
Lordship,
All
arbitration
over now.
application 87 of 2020 filed I filed one.
Item 162, I request personal notice.
Kindly maybe listed.
162, madam, personal notice. Proof of service.
Lordship, with your Lordship's kind leave.
It is all Mr. 5 o'clock. Where were you when I sat at 4 o'clock?
Lordship 87 of 20.
Even a special bench matter, you move around and then this all orders will not be changed, whatever I have passed.
Lordship 87 of
I am not accustomed to changing orders. This is a very dangerous trend.
This is an out of list matter, your lordships.
Where were you when the case was? I sat at 4 o'clock waiting for list to finish.
No, your lordships, I had come, your lordships had started. I apologize, your lordships. I could not make a mention at the beginning of the list. This is an IA number 1 of 2023 in arbitration application number 33 of 2019, your lordships.
It's not there, right?
Lordship,
What do you want? IA number, etc. I can't do anything. There is no file. I can't do anything with IA number. In which case, what do you want?
I'm requesting for the listing of the matter, your lordships. It's a matter.
Say so.
I request for listing of the matter next week, your lordship.
Where is mention member? Orally, not permitted.
Lordship 87 of
At
20.
least you should have written a mention memo in 1 hour.
Lordship 87 of 20.
File application for substitute the arbitrator reload. That may be posted next week. That may be.
You mention memo next week.
Mention.
You should better come when the court states, right?
Mention memo. Lordship 87 of
What is it?
mention next date. Listed.
Petition under 11.6. Petition under 11.6 of the Act.
No, man.
Let
No, Lord. Next to mentioning.
Huh?
Next date of hearing. Listed.
division bench matter, single bench matter. He is not answering. I am asking in petition under 11.6. He is not answering. What is your petition?
Arbitration application 87.
When I asked you, is it a petition under 11.6? Why were you silent?
Arbitration application 87 of 2020. I requesting the.
We are not concerned with this number 87 or 103 of 2020.
Next date of hearing. Kindly maybe
Will you help someone? Please, will anyone help me by looking at his mention memo? You see, Mr. Counsel, you see what is his mention memo? Give it to him. That what is it? Petition is unable to tell. His petition is under 11.6.
Not mentioned. They mention only.
I have filed one IA. Marking of document, return of marking of document. Appointment of